Heck yeah. We'll take that.
I never had any kind of rehab outside. I've been coaching for 38, I know staff, but I never. If they would just, if we could just go do the drug court, I could get out of here. So I can get out there and, cause I got a job. If I had to take the big day, I had a job out, I knew the money. And, if I not been with the traffic case, that was not long haul, that's not dope. That was no. I wanted to get some concrete.
What time are they gonna start?
It's supposed to be like.
Bobby said not to bring them out, remember that last time I was down here?
It's supposed to be 9 o'clock, but until I hear them say that they're, ready for us,
Then they hear everybody else's cases too.
if they're ready for us, then I'll put them out, and we're not gonna give them to them.
Right.
And hopefully see the judge come and say, hey, listen, y'all ready for us, let us know, we'll call in the rest of the attention, and we'll get them out.
I mean.
Because last time they stayed out here for what, 2 to 3 hours and didn't even see them?
5 for 5 or something.
Yeah. That was dispatch, I think.
Oh, well, let's see, Edison Patrol, 1395, South Highway 92. Boat storage.
Yeah. But I don't remember if it was hers or
you want to.
Sheds away from the president.
They were trying to bring them in an alphabetical order, but they said there's not even enough people out there yet.
Commonwealth of Kentucky versus Tony Albertson. Tony Albertson. Does anybody know anything about Tony Albertson? I guess it was a summons, and people don't respond to summons too well. Issue an arrest warrant. Bench warrant for Tony Albertson. Amy Angel. Amy Angel. Issue a bench warrant for Amy Angel. Tara Ayers.
I don't think she should be here. She had a positive test. I think she. I shared that with the Commonwealth and,
Does she have proof of that?
Yeah.
Where is it? Okay, you want to set her for October 14th. Sherry Barnes. And I talked to him, but I told him that he did not have the authority to release his defendants. You know, yeah. You know, he told me he told somebody not to be here. I said, you don't have the authority to. One of the things we do when people show up is take a look at them, see what they're doing, you know.
You want to arrest people?
Yes. Sherry Sue Barnes. Randy Beatty. Well, I mean, are there people downstairs? Okay, well, we don't know where to find them next time. Okay, I have to call the cases anyway. Brandy Beatty, issue bench warrant. Connie Brown. Issue bench warrant. Luther Connor. Luther Connor. Issue bench warrant. Joseph Craig.
He's on Zoom, Mr. Carroll.
Good morning, Your Honor.
Okay, we've called your client Joseph Craig.
Let me see if he's in my waiting room. He was en route. He called in earlier this morning, said he was on his way. We instructed him to come to our office so he could appear on Zoom here. Let me check, see if he's out front. He is here, Judge. Oh, wait a minute. I'm sorry. We're checking.
Issue a bench warrant for him. And you need to appear here. You don't need to come by Zoom, okay?
All right. I can head that way.
You don't have to today. You don't have to today, but in the future, you need to be here. I'll issue a bench warrant for Joseph Craig. Thank you.
Well, Judge.
Next case is John Diamond. And issue a bench warrant. Already called him, arrested.
That's Mr. Alderson.
Randall Dickon.
We should warn the rest of them.
Who is it?
Tony Alderson.
That's 5 after I'll go back. Randall Dickon. Cromwell versus Randall Dickon. 21 CR 0062. Are you Randall Dickon? Here today for sentencing. Have you had an opportunity to do the pre-sentence investigation report done by probation and parole? Is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced? On plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. The defendant has served 53 days and shall receive credit for the time served. He should be referred to social services clinician for long-term treatment. Should follow all recommendations. He shall receive credit, as I said, for time served. What's the court cost in this case? $155 court cost, gainful employment or 30 hours of public service. If you're not, you need some time to pay the court costs. I'll let you pay $30 a month. First payment is 30 days from today. Okay, you need to meet with the probation and parole officer there. Mr. Albertson, you're late. There's a bench warrant out for you. You want to come on up and do this? Commonwealth of Kentucky versus Tony Albertson, 21 CR 0004. Are you Tony Albertson? Last 4 digits, social security number 9471. Is that right? Okay. What you got here?
Your Honor, this is the case where the court has already signed the order for the process. Court says for making
Evaluation or what?
to,
Get behind the microphone.
Competency. Your Honor, I have no doubt in the fact about the ex parte motion. Mr. Albertson been indicted at least one time before, and maybe twice, KCPC is found to be competent. So I would ask that he go ahead and send KCPC while Mr. Shepard gets his expert.
Okay.
we've already got an expert, and it's in the process of getting that.
Well, he's entitled to an expert too, you know.
I just asked, and I know the case of PC would do that outpatient.
I don't care how to do it, it's up to KCPC. I don't think.
Sign an order, and Mr. Stockton, it's be your responsibility to contact them to see if you need to be in custody or out of custody. I'll sign the order either way, with preference toward out of custody because of the COVID.
That's fine with me.
Okay, okay. Cynthia Downing. She's setting for November 4th. Is that all right with you, Mr. Stockton? Okay. What? Yeah, we recall the warrant. Cynthia D. Downing. Are you Cynthia D. Downing? 21 CR 0095. What are the last four digits of your social security number? The last four digits of your social security number. Okay, you're here today for the purpose of arraignment. You have the right to remain silent, okay? Can you get hand her those earphones? You're sitting here.
She has a good service.
Okay, you need to arrest her. She hasn't been served, okay? And how did you know to be here today? How did you know to be here today?
That's how you do it here. For tax work.
She hasn't been served.
I call up about every other week to find out if, if I had a court date.
Okay, you need to arrest her and process her, and then I'll bring her back up in a ring. You need to explain it to her, obviously.
Cynthia, there's an outstanding advice of the warrant, okay? So they're not served it on. So it's like you know, but that has to be processed first, okay?
Now,
And you don't have to transport her to jail. You can process her wherever, okay? And you just keep her back here, okay? Commonwealth versus Cynthia Edwards. Stephanie Edwards. Could y'all announce Stephanie Edwards out in the hall?
I believe she co-defended with Joseph Craig. Said,
Issue bench warrant. Emmanuel Fluter.
that's the last time he said it.
There's no objection.
Well, we'll do him on the jail docket. You just put it in here on by mistake. Ferdinand Berger.
I believe he's been served.
You'll never see him again. He's out of state. He's got administrative release on a vision or something.
You gonna put him in NCIC?
I don't know if he wants it or not. He's got a action as long as you're in the law.
Yeah. When was he administratively released?
I don't know. It was an older case, I guess.
I'd like you to kind of try to find that. Is pretrial on here, Ben?
Yeah, Judge, I'm looking at it. I'm looking for it.
There won't be any more.
Judge, in the district court case, he was administratively released on May 14th. Of course, we're not doing that anymore on indictment, so it won't apply to anything future, so.
Okay, what's his bond in circuit court?
Looks like you've got a surety done set on the warrant, a $15,000 surety with curfew and subject to random drug and alcohol testing.
I'll make it $25,000 cash. Okay, thank you. Wendell Ray Hall.
He's another one. I think I tried him years ago, and I think had 59 years.
Those people out in the hall out there need to mask up. Every one of them, whether they work for a lawyer or whoever they are, they need to mask up. Feel like I'm in Tennessee. You know, they don't have COVID in Tennessee, do you? No, no.
My daughter was already.
Well, I mean, they act like they don't have it. Issue a bench warrant for Mr. Hall. Jeffrey Hunley. Commonwealth of Kentucky versus Jeffrey Hunley. 21 CR 0092. Are you Mr. Hunley? Okay. You're here today for the purpose of arraignment. Do you have an attorney with you? Okay. Will you stand in for arraignment here for Mr. Cross's client? This gentleman is going to stand in for arraignment for you, and then the discovery will be sent to Mr. Cross. Thank you. Give me the file there on Mr. Hunley. 0092. Mr. Hunley, the grand jury of Clinton County has returned an indictment charging you with theft by deception. Do you understand that? Counselor, do you acknowledge the identity of Mr. Hunley, the receipt indictment, waive formal reading and arraignment, and enter a plea of not guilty, reserving all pretrial motions?
Yes.
Now, I understand you're standing in for Mr. Cross, so after this, you're relieved from any obligation in this case. I'll sign a reciprocal discovery order, Mr. Hunley, and Mr. Cross can pick up the discovery from the Commonwealth Attorney's Office so you can help prepare for your defense, okay? October the what? Okay, you're to be here on October the 8th to negotiate your case. Your next court date is October the 14th, okay? Continue on the same bond. Michael Keith. You want him here on negotiation day? Well, if there's a trial set. You know what?
I don't see any set of dates. Charles wants to be with me.
Okay. What date's the trial set on? We'll check it here.
Yeah.
Okay, October the 6th to negotiate your case, and October the 14th. October the 8th, excuse me. October the 8th to negotiate your case, and October the 14th. you need to contact your attorney, Mr. Cross. And if there's no reason for you to negotiate, then you'll be here on the 14th, okay? Okay, thank you. Tim Kelly. Commonwealth Kentucky versus Tim Kelly, 21 CR 0087. Are you Tim Kelly? You're here today for the purpose of sentencing. What are the last 4 digits of your social security number? Who's your attorney? Where is he? Mr. Carter, will you, somebody from the Commonwealth Attorney's Office get a hold of Mr. Ramsey and ask where he is? You just have a seat back there, sir. Timothy Kelly. That's the same one. That was different. Charlotte Coger.
Your Honor, I represent Ms. Colger.
Okay, where is she?
I have been advised she's 10 minutes out from my office.
Okay, we'll issue a bench warrant for her. Thank you. Donnie Allen Lee. Are you Donnie Allen Lee? This is 21 CR 0082. You're here today. What are the last 4 digits of your social security number, Mr. Lee? What? Okay.
We have a felony police report.
Okay. A motion has been tendered that says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Okay, state your full name. Are you the same person named in indictment number 21 CR 0082? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you reviewed the evidence in the case? Do you believe like you're fully informed? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. In order to, before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to a speedy trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, to testify in your favor and have process issues, compel attendance. You have a right to appeal this matter to a higher court if you lose. You have a right to apply the Commonwealth for beyond a reasonable doubt that you are guilty of all the charges. You understand that entering a guilty plea that you give up those rights. I may consider the Commonwealth's recommendation, but I may also apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting your recommendation, I will order a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. If you move to your left, sir, step to your left, on over there. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Mr. Lee will plead guilty to possession of controlled substance, receive a sentence of 3 years, probated for 5 years, supervised for 5 years. He would pay $500 fine on failure to maintain insurance on a motor vehicle. Plead guilty. He would also plead guilty to operating a motor vehicle under the influence of alcohol or other substance. Second offense, it would be a $300 fine, so 7 days in jail. He would also be assessed with social service commission to pay court costs according to discretion of court, and all evidence in this case will be destroyed.
You want to step back over here, sir? Is that what you agreed to? Yes. You understand by entering this plea to DUI that it's enhanceable if you get into, this is your second DUI. But if you get another one, it even becomes more serious and it'll count against you guys in the future. You understand that? You understand by entering a felony plea that you lose certain rights here in the Commonwealth of Kentucky. And also, among the other penalties, if you have a felony in the future, the penalty can be enhanced because of this plea. You understand that? Are you pleading guilty, your plea with your own free will because you are guilty and for no other reason? Is it your constitutional, knowing your constitutional rights, is it still your desire to give up those rights and allow the court to fix your punishment as allowed by law? Okay, is that your signature on the document? I'll accept the agreement or pre-sentence investigation report number, probation, or parole, have you back here on October the 14th for the sentencing. You need to pick the probation parole officer right there. Yeah. Okay, we're gonna draw some numbers for the grand jury. Mr. Clerk, you have the file, you have the cards over there. Yeah, all the cards in there. Here they are for the record here. I'll pull this one up. Number 51. Caitlin Gross. Caitlin Gross. Number 67.
Jacqueline Logan.
Number 61.
Willard Johnson.
Do you need one more?
No, we need to join. So you want us to call them here?
Yeah, let me do one more in that way. You don't have 113. Have somebody over in the office call them, tell them to come in if they
Lisa
can.
Walker. Lisa Walker.
Lisa Walker. I'll-
I think we'll go call them, see what's going on.
Okay, thank you very much. Did we already do Donnie Lee Allen? Rebecca Major. Rebecca Major. Issue bench warrant. Rodney Manis. Rodney Manis. I've never seen anything like this. Issue bench warrant. I think some of these people are talking to each other across the- Joe Mason. Kenny Joe Mason, yeah. Commonwealth Kentucky versus Kenny Joe Mason, 21 CR 0067. Are you Kenny Joe Mason? What are the last four digits of your social security number? You're here today for a pretrial conference.
Your Honor, Mr. Mason has spoken, Chad and Robbie Scott. I submitted a conflict request. I feel like there's been.
Could you move over this way, Mr. So I can hear him? Thank you.
Your Honor, I submitted a conflict request. He's a co-defendant, Chad and Robbie Scott. I feel like it's been an assignment, but I don't know who that is. I'm assuming nobody here.
I'll check. We have this moment. This is, we've been getting conflict counsel for the last 2 or 3 months. I've left out a letter to DEA, joint conflict counsel. He was arraigned in July and September, so it's been 2 months already. They're going to get conflict, and I know Mr. Shepherd is diligent on this. He knows there was conflict, there won't be a conflict counsel, but he's a conflict counsel. Also, Melissa Jones has been appointed conflict counsel On another occasion, called previously, that she was supposed to be here and she's not been here. So, I noticed.
She's on several.
She's on several, so I don't know if she's on this one or not.
Judge, I just don't, I've had so many.
Somebody needs to contact her.
She might well be on this case.
She was on Brandy Baker's
Yeah.
case. And Brandy Baker was not here, and Melissa Jones was not here, and I signed an agreed order for her not to be at the August 31st negotiation conference because she was on vacation, but I put in the order that she had to be here September 9th. So, yeah, it's Brandy Baker, Melissa Jones,
I'm also with the city. I got a text from Michelle Wilson. She is on her way.
Okay.
So it's the attorney for Miss Baker. She texted, she is on her way.
Why did Mr. Bucks and then stick around since you represent him? I don't know.
I'm texting the office. I'm hoping for a response.
We call her. I'm not pleased with her. You know, they're on fast time over there. We start at 9, it's 9:30, it's 10:30 over there. And evidently she was also supposed to represent Mr. Connor, who was not here. And I doubt very seriously if she's been in contact with Mr. Connor. I'll find out when she gets here.
Well, I'm having difficulty with several conflict councils right now, other than Mr. Stevens, he's always shows up, Mr. Thomas does. But there's another.
Well, maybe we need to start keeping some of them with us over here. And if they stay a month, they'll be here on time. It's not your fault, Mr. Mason. Your attorney's not here. I'm gonna cut Mr. Mason loose for today. He showed up, his attorney didn't. You want him there for a negotiation day?
You need representation.
But we'll have him in representation by that day.
Okay.
Write down for Mr. Mason, you'd be here at the courthouse to negotiate your case on October 3rd and your next, October 8th, rather. And you'll be back here on October the 14th, okay? Wait just a second, they got it written down for you. And do we have a phone number on you? Make sure you write your phone number and we'll give it to your attorney. Shannon Mercer. Shannon Mercer.
Mr. Coffey.
What are those that pulled out that cost you? Issue bench warrant. Robert Lincoln Myers, Jr.
Yeah, that's more,
Do what?
that's more show up.
Robert Lincoln Myers, Jr. Let him behind the podium there, if you will. Are you Robert Lincoln Myers, Jr.?
Yes, sir.
This is 20 CR 0081 here for pretrial conference. What do you have in this case?
We don't have anything because he didn't show up to the case.
I'll say that. Your Honor, he was sick that morning. When I was leaving, he made late around. He had sent a message to the clerk's office that he was sick and wasn't sure if he was going to make it or not. So I would have support.
Well, there's a motion to be heard. The Commonwealth moves that his bond be revoked on the grounds that he did not appear at negotiation conference. What's your position, Mr. Stock?
Would you have to see if he goes without time? It says he's gonna be available September 15th, but that hearing date 1 o'clock.
I couldn't understand what you said.
I've got 2 different negotiations, I've got one for Mr. Sheffield, I've got one for everybody else, September 15th, 1 o'clock.
You be here September 15th at 1 o'clock, and then your next court date's October 14th, okay? 14th. Okay. Commonwealth versus Cecil Nevels. Commonwealth versus Cecil Nevels Jr., 21 CR 0094. Are you Cecil Nevels Jr.? Have you entered an appearance in this case yet?
Your Honor, we've not, I don't think he's even been formally served. I represent the district court. We were aware.
You need to identify yourself for the record, is what I'm
Yes,
saying.
Your Honor.
Put your mask back up.
Yes, Your Honor. Jeremy Barkley, 35 Public Square, Silver City, Kentucky.
Okay, take this young man into custody here and we'll process him and bring him back up.
Yes,
Okay.
Your Honor.
Okay. Commonwealth versus Kenny Norris. Commonwealth versus Kenny Norris.
What do you mean? Oh,
Issue a bench warrant for Kenny Norris. You what?
He knew he was supposed to be.
Okay, Commonwealth versus Billy Perigin. Commonwealth versus Billy Perigin, 21 CR 0078. Are you Billy Perigin?
Yes.
What are the last four digits of your social security number? Okay, there's a motion to revoke this gentleman's bond.
But he didn't show up in the negotiation thing.
Somebody needs to get behind the microphone.
Your Honor, he tells me that. That we had that day, and we also remember the next day.
Okay, you're in the custody of jail. Revoke your bond. We'll see you next month. Tina Perigin.
She called in, spoke with Thomas Attorney's office this morning. It's very sick. They said she's had horrible and they've been exposed. She's on for sentencing and just probated and she hasn't.
Tina Perigin evidently called in.
He called my office, clerk, she called the clerk's office, and they called my office. Spoke with Miss Beaver, and she's sick, she didn't know if she's going to be tested or not. She made a little exact note.
So you want, she's already entered the plea.
Yeah.
So she's just here for sentencing. She's gonna be probated anyway. So set her for October 14th. Need to draw some more. We need to draw some more people for the grand jury. I already sent number 98.
Candy, second.
Number 65. Number 60.
Nonetheless,
Number 74.
Joanne McCall.
Give me one more. Number 118.
Rebecca Young.
Jeffrey Paris.
Karen Parrish, Your Honor, I represent him. Mr. Parrish, I have a motion to enter guilty plea today.
Wait just a second. Let me get him around here. Commonwealth versus Jerry E. Paris. 20 CR 0053. Are you Jerry E. Paris? What's your year of birth, sir? Last four digits of your social security number. Counselor is in, where's my brain? Counselors informed me that you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? State your full name.
Jerry Harris.
You what?
Jerry Harris.
You get your full name.
Oh, Jerry Eugene Harris.
Okay. Are you the same person named in the indictment? Okay. Are you currently under the influence of drugs or alcohol? I asked you that previously. Is your judgment impaired in any way? Are you satisfied with the advice of your lawyer? You believe you've been fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that? What kind of plea do we have here?
Your Honor, it's a probation plea.
A felony plea or a pretrial diversion?
It's a felony plea.
Okay, okay. By entering a plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and go to trial. What is the Commonwealth's recommendation? You move to your left, sir, to your left. Mr. Carter.
The Commonwealth offers on a plea of guilty to trafficking or controlled substance first degree first offense, a sentence of 7.5 years probated for 5 years, based on a significant amount of time of credit the defendant would have, which at this time we believe is 426 days. The defendant would receive credit for time served, shall forfeit $259 to the Commonwealth to be dispersed in accordance with said forfeiture order. The defendant would do a minimum of 30 hours per week community service or obtain gainful employment, pay a fine and cost at your discretion, and remain on active supervision until all costs are paid or further request of probation and parole. And all contraband will be restored.
Is that what you understood? Step behind the mark. Anybody threaten or coerce you in any way to get you to enter this plea? Pleading guilty because you are guilty, for no other reason. Know your constitutional rights. I've explained to him your desire to enter a plea to the charges and allow the court to fix the punishment as permitted by law. You understand that upon entering a guilty plea, any future convictions of felonies will enhance the range of penalty under persistent felony offender law. You understand that? Is that your signature on there? What are the potential court costs in this case? Potential court costs be $155. You can either pay that or sentencing. And at that time, if you need some time, you can ask me, okay? I'll accept the agreement, order of pre-sentence investigation report. You'll be back here on October the 14th for sentencing. You meet with probation parole officer right over there, okay? Yes.
Had an error on his calendar. He thought he entered the diversion plea, not a probation plea, and didn't realize he had to be here. He's out of town. So Molly said she would stand in with that sentence and the case, and she stopped it.
Actually, no, I just have the client review the PSI. And
Call it up in a few minutes and I'll pull it up. Next is Commonwealth versus Bobby Ray Phillips. Bobby Ray Phillips. Schedule. She's got something for
He already has a probation violation for stopping.
Okay, we'll do a bench warrant on it without bond. Okay, put another warrant out. We've got 2 outstanding warrants. Several pages here. Jesse Phillips. Jesse Phillips.
That's another one, Miss Wilson.
Miss Phillips, Miss Jones. Miss Jones did have Mr. Mason. But we are still looking due to the number of people that conflict out of this particular case. Miss Phillips, we've got our state office in Frankfurt trying to find this conflict. Case and also another. That's the number of different people that conflict out the same.
Are you Jesse Phillips? You'll be back here on October the 8th for negotiations. And your next court date is October the 14th.
That's at 1 o'clock on the 8th.
Do you have his telephone number? Ricky Phillips.
Judge. See, that's Miss Stanziano's case, and she's not here. But Mr. Phillips has emailed me along with Stephanie Edwards with a picture of a flat tire. And says they are having car trouble and gave me an email address to send them a Zoom link.
I think that transportation, because they know where things change. It's the courthouse, some of them, I think there's a reason they don't want to be here in person. It's nice.
Tell him, send back a message and tell us where he is, and we'll send somebody to give him a ride. If he doesn't respond to that, I'll issue a benchmark.
It's true.
Taylor Phillips. Is that who's riding with him?
No, it's Stephanie Edwards.
Taylor Phillips. Issue benchmark. Terry Phillips. Issue benchmark. Shannon Portman. Commonwealth versus Shannon Portman, 21 CR 0051. Are you Shannon Portman?
Yes.
Last 4 digits of your social security number are what?
0495.
Okay, you're here on a motion to revoke bond.
Yeah, he wasn't the last negotiation.
Can you get behind the podium?
I don't think he was aware of that. He missed in August because of COVID. So when that date was handed out, he's not made aware of it. He is here today. So, you gotta know that. He was not made aware. That's my fault.
Well, why wasn't he here in August? Good question.
August 12th, he had COVID, so he wasn't here for those days that day.
He has proof of the COVID here, unlike most people.
Yeah, we put him on the distribution on the order.
You were here on this one negotiation, but one here on this last one, on the 33rd one. And Your Honor, Shannon's done, you know, he made all the four appearances in his for a year and he's working, I would ask the court.
Where are you working?
Ours, ice, hard burn, so.
Okay, well, you be here on October the 8th at 1 o'clock. And I don't want any excuses, okay?
Your Honor, we're not going to settle this case.
I still think we can settle.
No, okay, I was misled. His uncle called me and told me that he was going to make restitution in this case. And I let him out on the phone. And since that time, he and his grandmother have not made restitution. They continue to refuse to make restitution, so I'm asking for a trial.
Okay.
He doesn't really need to be out of jail. That's all the seat.
Because what?
Because I was deceived.
Y'all move to the left here. Move to the left. Okay. Now, let's get to trial. For y'all are out.
Mr. Phillips and Miss Edwards say that they are catching a ride now. They'll
Hope springs eternal that people can catch a ride. Evidently, your all's cars are not adequate enough or acceptable for them to transportation. You tell there's been a complaint to the sheriff about the quality of your cars. Yeah, I don't know. Might be those cages in the back of it that people don't like. Are you available on December the 14th for trial?
Other than that being a district court day.
I don't want to, I don't want to do it on district court day.
Justin, can you confirm that I'm right about that? December 14th.
How about December 13th? No, he says there's no reason to do a free trial. $89.
Ryan.
100,109,109.
James Taylor.
37.
Billy Gaffron.
And 16.
Julie Brown.
Commonwealth versus Troy Pryor. Troy Pryor. Como versus Troy Pryor. 21 CR 0059. Are you Troy Pryor? For the last four digits of your social security number. Your day for a pretrial conference.
Your Honor, I think there's also a rain.
That is correct. You here for a, there's no doubt. Are you Troy L. Pryor? You previously identified yourself in your other case. This is a 0096. There's an indictment. The grand jury of Clinton County has returned indictment charging you with trafficking and controlled substance in the first degree. You understand that charge? Counselor, do you acknowledge the identity of Mr. Pryor received indictment? And your plea of not guilty, reserve all pretrial motions.
Yes, Your Honor.
Okay, what's the Commonwealth want to do on this? Set a negotiation day or the 15th? And then September 15th at 1 o'clock and be back here October the 14th for your next court date. Have to be both of those things. You understand? Okay. Commonwealth versus Chad Scott. Chad Scott.
He
Yes.
is on Zoom. He has a positive COVID test. He provided it.
Okay. He's here. Attorney, he has a positive COVID test. He submitted proof. Are you Chad Scott?
Yes, sir.
Okay, who's your attorney?
I'm both of them.
Opinion case here. You want to come up, Mr. Robbie Scott? Now you can see the screen over here. Come up versus Robbie Scott, 21 CR 0069. These, both these gentlemen are charged with theft and lawful taking of vehicle, $500 or more, but under 10,000. And you're all, Mr. Robbie Scott, you have a persistent felony offender charge. Mr. Stockton, what do you want to do on this case here? These two. Why weren't you here on time, Ms. Jones? Why?
Terribly sorry about that.
It's not a good day not to be here on time. It's a confusing day. People are not showing up. I mean, if you have a good excuse, answer, so I'll accept that. You're excused for not being here, but don't do it again. If you come up with some lame excuse, it's been a bad day. Okay, you represent Robbie Joe Scott, is that correct here? Okay. Okay, well, so get our Scots mixed up here. Okay, so you want them here on, you represent both of these fellows, Chad and.
I'm a little bit worried about Chad.
Well, I'm gonna,
Mr. Scott, both Scotts, and Mr. Mason on October 14th. And have conflict counsel here for Mr. Mason, so I can get a pre-trial negotiation day on all of it.
October the 14th, and Chad Scott and Robbie Joe Scott, okay? A minute. I guess. Do you have room back there to put them in?
Yeah, I'll bring you back up to the whole thing. I'll take it to Wayne because I need to know. You know.
You jail, sir. Perfect day. Yeah, this is good. Just take them back. Any of these people that show up late, just take them back there and lock them up in this cell here. And then we'll separate them and we'll call them back out later. Jamie Nicole Scott. Commonwealth versus Jamie Nicole Scott. 21 CR 0026. Are you Jamie Nicole Scott? What are the last four digits of your social security number? Your counsel, you want to, okay, ma'am, you want to stand over this way and let your counsel enter appearance. Would you identify yourself for the record?
My name is Michelle Wilson Jones.
Okay. What does the Commonwealth have to say about Jamie Nicole Scott?
Well, this is the first time she's had an attorney. I'd like to have a negotiation.
A negotiation date,
I don't know which one's better for this. October the 8th or September the 5th.
okay, be here, young lady, you to be here on September the 15th with your, and you discuss the case with your attorney before then. Your next court date is October the 14th. You need to be here on both of those days. Both of them are a condition of your bond. You understand that? Okay, thank you very much. You have the discovery counselor in the case.
I have received.
Okay, thank you. Commonwealth versus Jimmy Simmons. Issue bench warrant. Commonwealth versus Lloyd Ear Smith. Lloyd Smith. Issue bench warrant. Johnny Lee Stevens. Commonwealth versus Johnny Lee Stevens. 21 CR 0076. Are you Johnny Lee Stevens? Okay, what are the last four digits of your social security number? Okay, what do we have in this case, Mr. Green? This is Johnny Lee Stevens.
Yeah, I guess sometime in January along with other plan.
All right, you gotta move over here. I can't understand you.
There's another landlord clinic case set in January. I've asked this one to set in January. I've told both of the victims of these cases to go ahead and file suit. And see if they can recover the civil if they can't, and I'll proceed with it.
How much is involved?
I think about $6,000.
Eleven to 12.
Somewhere in there. We'll set this one into the 10, 11 to 12.
Well, we've got Commonwealth versus Cope.
Yeah, that's the other case I told the landlord to file suit.
So you want to set this one at the same time, or?
We said one of the other days, or it's back up either one. However you want to do it.
Well, I don't have my rule days on here yet.
It'll be the 13th, 20th, and 27th.
Let's start this case on the 10th.
Okay.
And then we'll go over those 3 days will be our landlord stuff, okay?
Hopefully that'll give them time to just see.
And it's same, he has a code of.
And I mean, some block.
Is there a co-defendant here? What's your name? Okay. This is 21 CR 0074. That was Johnny Lee Stevens that just left. What was the date?
10th and 11th of January.
Okay, you'll be here on January the 10th. Ready for trial, okay? Commonwealth versus Eric Ray Story. This is 21 CR 0019. Are you Eric Ray Story? Okay. What are the last 4 digits of your social security number? You're here for a pre-trial conference. Your attorney says that you wish to enter a plea. Is that correct? I'll get to that. I'll get to that. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes.
State your full name.
Eric Ray.
Are you the same person named in indictment number 00019?
Yes.
Have you discussed this matter with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Evidence that the Commonwealth has against you, you feel like you're fully informed.
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to be on a reasonable doubt that you're guilty. You understand that by entering a guilty plea today, you do have those rights. Is this a felony plea?
It is,
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept their recommendation. In the event I do not accept their recommendation and you just decide to impose a harsher penalty or sentence, you have the right to withdraw your plea. Now, will you step to your left, sir, you and your counsel to your left? on over to your left, you come over here, your left. Okay, move away from the podium a little bit. Okay, Mr. Carter, what is the Commonwealth's recommendation?
Your Honor, the Commonwealth would offer upon a plea of guilty to traffic control first offense, first degree. The defendant will receive a sentence of 7.5 years to serve. The defendant has 141 days in jail and will receive credit for that. After he serves 39 more days, for a total of 180 days, we would not object to shop probation. The defendant will pay fine and costs at your discretion and agree to have any and all contraband and controlled substance disposed of in accordance with the laws. And upon obtaining shop probation, he would either do 30 hours per week of community service or have a job.
Well, why are you doing shock probation? What? Do what? Okay, that's a good answer. Why are we even talking about shock probation? But that's okay. That's all right. It's okay. Okay, you want to get back behind the podium here? Okay, is that what you agreed to?
Yes.
Okay. And you realize that after entering this plea, you have an additional felony on your record.
Yes.
And if you have another felony conviction or plea, you could be sentenced to more time on the persistent felony offender law. Do you understand that? Does anybody threaten or coerce you in any way to get you to enter this plea? So you're aware of your constitutional rights as I explained them to them. It's still your desire to go ahead and enter a plea and let the court fix your punishment. Is that your signature on the document?
Yes.
I'll accept the agreement. And you are to be back here for sentencing on October the 14th. You need to meet with a probation parole officer there so they can get the information down to do your pre-sentence investigation report. Okay? Thank you very much. Have a safe trip. Good seeing you. Kenny Stuber next. Andy Stuber.
Motion.
And Jonathan Stuber.
There's motions on both of them.
Are you Candy Stuber? Yeah, this is 00025. You're Jonathan Stuber, 0024. We have motions in this case. What do you have?
We had made a last proposal during the negotiation conference, but I think Mr. Jessup has already excused.
Actually, it turned out I was wrong.
Okay, you want to get behind the podium, move them boys.
Right now, you're likely there is one of the other defendants in the case. I don't know what's almost going to do with the private. One of the other defendants gets a bill to not council, but council other than.
Another pre-trial, so we now get council, trial, not to get a trial date for all of it.
October September the 15th, right?
I don't see need to have them back.
Okay. October the 14th. Y'all be back here on October the 14th to either enter a plea or get a trial date. Chris Thrasher. Commonwealth versus Chris Thrasher, 20 CR 0087. You are Chris Thrasher.
Yes, sir.
Counsel, have you entered appearance formally yet?
Yes, Your Honor. Greg Oosley on behalf of Mr. Thrasher.
Okay, we're here for a pretrial conference. What does the Commonwealth have to say?
This is a special prosecution.
Where is this?
Matthew Laven's office.
Okay, Your Honor.
Yeah.
Your Honor, I spoke with the Commonwealth, with Mr. Matthew Lever on the way down here. He said he was aware that there was court today. He did tell me that
Let's get him on the line. Can you get him on the line?
Yes, Your Honor.
You all see it, check, make sure it's on the, he's on the next distribution.
There was some good version, that's not bad.
Mr. Leonard. So can I put you on speaker phone so we can address Judge Williams together?
Mr. Leverage, can you hear us? What do you, are you ready for trial in this Chris Thrasher case? That is the question. Hold it behind the microphone. Hold it behind the microphone.
We expect to lead to significantly it would not necessarily be the same, as there would be different charges. There might be some overlap.
Okay, would you like to set this then for October 14th for another pretrial? Or do you want to set it for November 4th in anticipation that additional charges might be brought to the grand jury? Hand the phone up here. You just hold it right there. Would you like to set this for a pretrial on October 14th or November 4th? The grand jury will not meet again here after today until October 14th. If you anticipate you're going to go back to the grand jury on October the 14th, then you might want to do it on November 4th.
November the 4th would be great.
Okay, we'll set the next court appearance on November the 4th. Now, do you have any additional information that you do not want to disclose, but might want to talk to counsel about off the record that would indicate there needs to be a change in a bond condition?
Not right now, Judge.
Okay, that'll be fine. You'll be continued on your same bond. Be back here in court on November 4th. Okay, thank you, Mr. Leverage. There you go. Yeah. Sure. Have a great day. Commonwealth of Kentucky versus Heron Tuggle. Commonwealth versus Heron Tuggle. 20 CR 0064. Are you Heron Tuggle?
Yes, sir.
Okay. Last four digits, social security number 1135. Who's your attorney?
It's Miss Stanziano. I have an email from her.
What does she say?
She sent an email at 9:59 a.m. that says, I continue to have active symptoms. Instead of getting better, I continue to get an additional symptom every day. In addition to the blisters on the bottom of my feet.
I don't want to know the gory details. I appreciate it. Yeah, what?
I don't know, we might have this process of January, or APO, get other conflict, but Stanziano never meets when she's supposed to.
Okay, I want to remove Ms. Stanziano from this case and direct the Office of Public Advocacy to have substitute counsel. Your next court date would be on November the 4th. Okay, now you're gonna need to get a number here from the Office of Public Advocacy. So this right on the back of the card there that used to be here on November 4th, okay? Now you call in there about 15 days before November 4th if you hadn't heard from them, okay? You have some grand jurors, Mr. Clerk. You got enough now? Go. Grand jurors want to come around. Thank y'all for coming on short notice. You'll raise your right hand. You solemnly swear or affirm that you will conduct your duties as a member of the grand jury of the Clinton Circuit Court. You consider all matters and keep them confidential, that you protect and defend the Constitution of the United States of America and the Commonwealth of Kentucky. So help you God.
Yes, sir.
Thank you very much. You'll go with the clerk. He'll take the grand jury room. Thank you very much. Commonwealth versus Joe Turner. Commonwealth versus Joe Edward Turner, 20 CR 0065. Are you Joe Turner?
Yes, sir.
Okay. Do you have attorney? Mr. Shuff, is this your client?
Yes, Your Honor.
Okay.
Your Honor, Mr. Turner was here on the day on April 1. He also met with me Tuesday of this week to review some discovery. And the disc that I had in the discovery was not working. It was on REM. I got a new disc from Commonwealth this morning, so I'm hoping that that's going to work just fine. If what Mr. Turner does, I think we'll do that before we move forward.
September 16th, was it? 15th, September 15th. You want to meet with the Commonwealth again?
Well, he and I need to meet separately. It's going to take a little bit of time for us to review this. Probably not that little, but he and I want to come together.
Well, I'm talking about when you're going to meet with the Commonwealth.
Well, Judge, I don't know that, I mean, this one, Jesse for years, Jesse and I for years worked cases without having an official day.
Well, y'all can work this one out. If he tells me it's okay, and I'll set you for
Let's say October 14th.
October 14th, okay? You'll be back here on October 14th, and you be good, you keep in contact with your attorney, okay? Danny Wade Tweedy. Danny Wade Tweedy. Danny Wade Tweedy with a W.
That case, there's order dismissal.
Yeah.
Okay. Donovan Waller. Speech impediment, Danny Wade. Commonwealth versus Donovan Waller, 21 CR 0023. You Donovan Waller, you're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done with probation and parole? Take the sunglasses off the top of your head, please, and put them aside just for camera purposes, okay? Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty to traffic and controlled substance, first degree, the defendant shall receive a sentence of 5 years, probated for 5 years. He shall serve, I can't read what it says there. It's 120, what does it say there? 90 is marked out and there's an interlineation.
Complete the Clayton County.
No, the defendant shall serve what days?
128.
Well, it's, have you got the plea agreement in front of you? Look like it might be 128. I don't know what it
I'm
means.
saying he has served
Has served.
128
Okay.
and shall have credit for all that time.
Has served 128. Okay. So he didn't, you don't have any additional time. Okay, she enter and complete the Clinton County especially your drug court. What are the court costs in this case? Court costs are $155. You need some time to pay that? Okay, you pay $30 a month, starting 30 days from today. And you need to meet with the probation and parole officer there. Is that correct?
Yes.
You want to give him a number or a time, or you want to talk to him now? Okay. Go over there and talk to him, okay?
Thank you.
Okay, thank you. Alicia Dawn White. Commonwealth versus Alicia Dawn White, 0079. Are you Alicia Dawn White? You're here today for a pretrial conference. What do we got going on here?
We filed a motion to vote on the. Your Honor, I spoke with Alicia yesterday and.
Okay, you're in the custody of jail. We'll see you next month.
Your Honor, she's been in Florida Patriot for over 9 months and it's a good standing there. Obviously, she can be able to 30 days or thereabouts on with the job. Would the court consider a fine in lieu of jail time?
What does the Commonwealth have to say?
I'd be agreeable with less since she's been working, unlike Mr. Perry.
Okay, I'm gonna fine you $5. That's the break of the day today. But you've at least made some effort to be here. You're working, and a lot of these other people aren't doing either. So you make sure you don't miss any other court days, okay?
I've heard say here on September 15th.
September 15th and the next court days, October 14th.
They serve the warrants, the Downing and the Neville.
Let's call Commonwealth of Kentucky versus Cecil Neville. Cecil Neville. You be sure you pay that fine or we'll come get you. Commonwealth versus, yeah, Commonwealth of Kentucky versus Cecil Neville Jr. Are you Cecil Neville Jr.? What are the last 4 digits of your social security number? Are you here today on arraignment? The grand jury of Clinton County has returned an indictment charging you with assault in the 2nd degree and assault in the 4th degree. You understand those charges? Counselor, will you enter your name into the record?
My name is Jerry Bartley.
Okay, do you acknowledge the identity of your client has received the indictment, waive formal reading and arraignment here, plea you're not guilty, reserving all pretrial motions?
Your Honor, identify Mr. Neville's away formal arraignment.
You reserving all pretrial motions. I'm signing a reciprocal discovery order. Mr. Neville with Commonwealth will give your attorney the information they have. If he needs additional information or feels like the Commonwealth has not completely complied, you can file a motion. You have a right to receive that information. What does the Commonwealth have to say about this case? You want a pretrial?
Sorry, October 8th, 1 or 3 years. October the 8th, I have to look at the read that's just written. I think that's. October the 14th.
October, you'll be back here on October the 14th. Is there any complaint about the conditions of his bond?
Your Honor, if I understand correctly, the indictment warrant that are bond at 20,000 cash or property. He had posted 10,000 cash or property. It's been about 6 months. There's been no incidents whatsoever. He resides in Pulaski County. He has a job with building compliance and maintains full-time employment. Has no reason to be here in Clinton County anywhere near the locus of your allegations, Your Honor. I'd ask if the court could amend it consistently with the prior bond.
What's the bond he's made now?
He hasn't made one. He was just served today.
Just served today, so he's been avoiding this. See, I'm not a real big fan of people that just show up here on court day and lay low between now and then. I just think that that's playing the system. Now, if he had turned himself in and he was aware there was a warrant out, how did he know to be here today?
Yes, sir. Yesterday afternoon was the first time they attempted to serve him, and the client reached out to me. I spoke to the juries that had been out to serve them. They had already left for the evening, and they weren't.
Well, I will, has he got 10,000 cash up? What has he got? What is the bond he has up now?
Mr. Chairman, he posted 20,000 property, it's my understanding.
Is that right, Ben?
Judge, I'm looking at the district court case. Looks like he was released on a $10,000 surety bond on April the 7th with ankle monitor.
I thought he posted property actually with his girlfriend, but he can post 10,000 cash for property.
Do you have an ankle monitor on?
He does not currently, no, sir.
But the bond on the warrant, Judge, for you right now is 10,000 cash, twice property, with home incarceration, no contact with victim.
How did he get off the ankle monitor?
I don't know, Judge, unless when he got indicted. I don't know. I don't have anything to do with that unless he got indicted and they have something sent, releasing that bond. That's the only thing I might think of, so.
In the district court trial. No, there's nothing in here regarding the district court trial.
What's the Commonwealth have to say about this? You want to step to the left here? Y'all want to step to the left here?
This is going to the docket district, and we realized Mr. Neville's had been served, so we called the state police to try to keep him served, so I was confirming that part. So if he can make a $10,000 cash, $20,000 property bond, I have no objection, and I don't.
This is odd all the way through here. I mean, he had this $10,000 and then he had an ankle monitor on.
Was that through district court?
It was through district court.
I don't know.
And, it wasn't ever an ankle monitor. And then he's never been served.
Very not be on my monitor,
Yeah.
Judge,
You want to move back behind you?
yes, sir. I represent Mr. Mills at district court, and there was never a directive to hook up on an ankle monitor. They may have entered an order to that extent. I don't recall that ever being conditioned. We spoke about this a couple times. We offered it.
I'm set for the file. It's a Class C felony he's charged with.
Yes, sir.
One thing it says is Judge Lawson just made a note that the bond remains the same with the exception of the ankle monitor. So when he took off the ankle monitor,
Okay, okay. What was the bond there?
the 10,000 surety. 10,000 surety.
Who signed the surety bond?
I believe.
Wait.
Patricia Smith?
That the girlfriend?
Yes, sir.
You have any objection to that bond, Mr. Stockton? It's $10,000 surety bond?
Security, I thought it was cash or property bond.
It's surety bond. But you say he has no reason to be in Clinton County, so I'll add a condition of the bond that he stay out of Clinton County and not approach or contact the victims, alleged victims. Now, I also do a curfew. Are you working publicly?
Yes, sir.
Okay, I think that you need to be able to go to work, church, the doctor. Any other thing, you need to contact our pretrial people if you're going to be around anywhere else, because we want to keep kind of an eye on it. But I won't put you on the ankle monitor since Judge Lawson took you off of it, okay? So the pretrial number, Ben, will you give him a pretrial number? Ben's on the Zoom here. You got a pen that you can write this down for this gentleman? Ben, give him a number here that he can call you.
Okay, he can call me directly at my office. It's 270-343-1371.
Okay. Now, the conditions of the bond, he's going to stay on the $10,000 surety bond. He's going to stay out of Clinton County. He's going to be on a curfew, and he's not to contact the alleged victims, okay?
Yep, got it.
Those are breach of other laws, okay? Now, you want him here on a negotiating?
No, we discussed that, Mr. Bartley told me.
Okay, so the court date is October 14th, okay?
Is that at 9 o'clock central, Your Honor, on that day?
Yes.
Your Honor, two additional items, if I may.
Yeah.
Briefly, the court didn't mention, I assume it goes without saying, but I don't want to go without saying. Could the exception include to meet with me?
Sure.
As necessary, and
Well, what he needs to do is he needs to call in a pretrial and say, I'm coming over to the attorney. Anything that's not mentioned, if you gotta do anything else, you need to call pretrial.
I explained to Mr. Mills is to treat them, that's his mother, her father, and to do exactly as directed, Your Honor. The other question was, again, probably goes without saying, but I assume court appearances are an exception to the
Yes,
Clayton County Prohibition. Your Honor, I just want to make a double sure.
yes,
Yes, sir.
he can come here to the courthouse.
Yes, sir.
Okay, thank you very much. You can be on your way.
Your Honor, and I'm sorry, one additional item in terms of practicality, is the district court transferred or shall he?
I'm gonna transfer the bond up here because when they sign the bond, it says for all court appearances. Doesn't specify just district court. So she doesn't have to come back in and sign again. He doesn't have to go to jail.
Yes, Your Honor, that's what I want to make sure. I'll make sure-
Okay.
make sure we comply. Thank you, Your Honor, that's all I have. Thank you.
Have a great day. Yeah.
Yes, you too, Judge.
Commonwealth of Kentucky versus Cynthia Downing. Is that the next one you said? There's Jeffrey Conrad. Commonwealth of Kentucky versus Cynthia D. Downing, 21 CR 0095. Are you Cynthia Downing?
Yes, I am.
Okay. Just drop that first. Okay. Counselor, do you acknowledge your identity? Receive the indictment. Can you hear me, Ms. Downing?
Yes, sir.
Okay. You acknowledge her identity, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all free trial motions.
Yes, Your Honor.
Okay. Assigning reciprocal discovery order. What was the bond set on this, Ben?
Judge, looks like it was a $15,000 surety bond with your curfew with standard exceptions and then subject to random drug testing.
Did she make a bond in district court?
She was released on a $5,000 surety bond in district court.
Have any objection for continuing the $5,000 surety, Mr. Stockton?
No, Your Honor.
Okay, I'll continue the $5,000 surety, but you're under curfew. You don't go to anywhere but home, church, or the doctor, work, unless you call in the pre-trial release. You understand that?
Yes, sir.
Here, what do you want to do with this case? Be here at September 15th for negotiations at 1 o'clock. Your next court appearance is October 14th, and both of those are a condition of your bond. You understand that? Okay, thank you very much.
Well, these are the people that are showing up.
What about Tim Kelly?
Yeah, he's ready. That was the one that Ray Ramsey.
Tim Kelly?
That's all he's done.
Commonwealth of Kentucky versus Tim Kelly, 21 CR 0087 and 21 CR 0053. Mr. Rhett Ramsey, your counsel of record, is allowing co-counsel here, or instead, do you have any objection to that? Okay. Okay, turn to the, move over here to the left.
There's a substantial amount of restitution, $5,000 or $6,000, and it's not been paid, and he had 30 days, and that would be money. And I don't know if I want that paid before we send it in or not, because if not, I'll just be back there on the motion for vote.
You need to talk to your attorney first. Step away from the podium and talk to her.
Your Honor, may I respond? You actually spoke to me about this. So under the agreement, my understanding is he had 30 days for entry of plea, which would be due this coming Monday. He's asking for an additional 4 days to have until Friday to pay.
Okay, he shall appear back in court here on October the 14th for sentencing. That'll give you more than 4 days. And you need to have it done by then. If you don't, I'm sure pardon? Yeah, okay, thank you very much.
Thank you, sir.
What about, I have Ricky Phillips is the only one I have left.
He was one with the car trouble. But he and Stephanie Edwards, they're supposed to be,
Did I turn her over?
yeah, because you had called her before I got the
Okay,
email.
let's have a bench warrant for Mr. Phillips. There's no place in Clinton County you could have been here by now. Okay, that concludes the docket. Wait just a second, wait just a second. Wait just a second. Did we call their cases previously?
They were called Miss Bates' attorney. Was not present at the time.
But, yeah, he's got a hold of this.
The two that had the flat car.
Who do you have? Commonwealth versus Wendell Hall. Thank you. Okay, let's come back to order here. Okay, everybody kind of fade away. Commonwealth versus Wendell Hall. Are you Wendell Hall? It's 21 CR 0093. Here today for the purpose of arraignment. You can, what are the last four digits of your social security number? Last four digits? Okay. You're here today for purpose of arraignment. You have a right to remain silent. Grand jury of Clinton County charge you with operating a motor vehicle under the influence, operating revoked, no registration, no insurance. You understand those charges? You acknowledge the identity of your client, see the indictment, wait for more reading arraignment, interplead not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. What does the Commonwealth have to say? September 15th at 1 o'clock and October the 14th. Both of those are conditions of your bond to be there present both times. You understand that, sir?
Are you gonna withdraw the warrant?
I'll withdraw the bitch warrant. Which one is it?
Wendell.
You put no list on the list.
Then they were-
Who are these two here? Car tire people.
No. Maybe. I don't. Probably. But
You don't have to recognize it. You gotta get out. Okay, is that it? Who's with Miss Bates? Who are these two people here?
They're the ones that had the flat car.
Who are they?
Stephanie Edwards and Ricky Phillips.
Are they co-defendants? Or they got different cases?
no, they have different.
Just run together.
Mr. Phillips is represented by Ms. Fanzion.
Commonwealth versus. Who are you? Who is she?
Frank, baby.
Why weren't you here, Miss Beatty?
No, she was, Your Honor. I was.
You were not. Okay.
He wasn't here. No, sir, not.
She wasn't here either.
when her
And
name
don't
was
get
called.
started off misrepresenting something in the court here. I mean, you already got off the hook before here. But I'm gonna call Ophel King and report you.
Please.
Yeah, that'd be fate worse than death. Okay, what's the deal on Miss Baby here, Commonwealth?
We just didn't negotiate one. We never had one. September 15th, all right.
September 15th at 1 o'clock. And then your next court date is October 14th. Now, why weren't you here on time? Okay. You blaming this on your dad? You want me to hold him in contempt or? Okay, well, that's good. At least you won't throw your own father under the truck, you know? Okay, you be here at those 2 dates and you be timely, okay? Okay,
Withdraw the warrant.
I'll withdraw the bench warrant on you, okay? Okay, is that all you have? Okay, no problem. Have a good day. Now, who are these other two back here? Stephanie Edwards. What versus Stephanie Edwards? Well, she's in there. don't she?
Yeah. No worries.
I don't know anything about it.
Hold it up.
No, but that's not the issue. with bench warrants.
Yeah.
State your full name for the record. Okay, this is 21 CR 0074. You're here today on pretrial conference. What do you have here?
Your Honor, we have a police report from sheriff. This is a felony.
Your attorney tells me you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Tell me the last 4 numbers of your social security. Are you the same person named in indictment number 21 CR 0074? Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about the case. You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. You have the right not to testify against yourself. No one can make you say anything. The right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter in higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt the charge against you. Did you understand by entering a guilty plea today, you gave up those rights? Now, is this going to be a diversion plea or a felony plea? Okay. You step to your left, both counsel, you and your client, listen very carefully.
No, I'm sorry, it's a felony.
Okay. Okay, okay, this is a felony plea. You go ahead and announce it.
It's a, she will plead guilty to criminal possession before detention. She will receive a sentence of 5 years, probation, 5 years supervised, pay restitution amount $2,450.74. The monthly rate $200 a month. Again, within 30 days from today's date, she'll have restitution of 5%, pay court costs at the discretion of the court, obtain and maintain gainful employment, and be under active supervision until all costs, fines, and restitution paid for.
Is that what you agreed to? Come back over here. Is that what you agreed to? You'll by accepting this plea, you become a convicted felon. If you have any felonies in the future, your sentence could be enhanced. Is that right? You know that I do not have to accept the plea. After I review the pre-sentence investigation report, which I'm ordered in a few minutes, if I decide to give you a harsher penalty. If you don't, you cannot agree to a harsher penalty. You withdraw your plea and have a trial. You understand that? Are you satisfied with the advice of your attorney? Okay, well, I'm going to order a pre-sentence investigation report in order you to be back here at 9 o'clock on October 14th for sentencing. Probation parole officers right there, okay? Thank you very much.
Ricky Phillips.
Ricky Phillips. Commonwealth versus Ricky Phillips, 20 CR 0019. Are you Ricky Phillips?
Yes.
You're here for pretrial conference.
That's Ms. Stanziano.
Okay, I'm with removing Ms. Stanziano as your attorney. And we'll have another attorney appointed to you, and you'll be back here on November the 4th. That'll give us some time to get another attorney. Okay, you need to get, wait a second. Will you give him a card for the public defender's office? give him a name. What about all those clients?
You're on the list, everybody there. These are the other custody. Over here.
This is it, right? Including process.
No, that doesn't include process.
Okay.
These are just the people that have
I
showed up.
know, it crosses. I think it was. It's clients here.
None of them are here.
I know. I know. I'll take a look at it. Luther Connor, is he here now? Who represents Luther Connor? Did she leave?
So you called the case earlier, it was a warrant, so it wasn't.
She left the building, Linda?
Mr. Stevens is gonna call and have him back.
You just go back there and have a seat. Take him back. Kenny Norris.
He didn't show up.
He showed up.
Did you say that Bethany had sent you an email? Before that, time to work on the conflict.
Kamala versus Kenny Norris.
She doesn't refer to her clients by the correct name in that email, so.
Are you Kenny Norris? Where were you this morning? Where were you this morning?
Waiting for me,
Put-
call in, dude, I'm gonna name down the. Eventually, you know, I had the word.
Put that up over your nose. I don't understand what you're saying. Where were you when your case was called? Where were you when your case?
Outside, sir.
Okay. Who's your attorney? What have you got to do on this case? Okay, move over this way, Mr. Norris. Move over this way. What's Commonwealth have?
It's a motion to revoke, Your Honor. I just want to see our-
Can you get up behind the microphone here? Thank you.
He's only made two restitution payments, one in the amount of $95.24 on 9/8/20, $66.67 on April 5th, 2021. He still owes the balance of the restitution. And Mr. Payne informed me too, he may want to explain this story, critical, he wasn't on the last report. He was on that policy.
It was on site positive this past Friday for pregnant buildings, and I'm waiting for the test to come back from the lab.
Well, I don't know. I'm just waiting to see what they have to say about it.
But, Your Honor, we like to see those lab results come back. I'm sure that the reason they was off is because he not use of time, like correct. And in the meantime.
Well, what did Kenny enter a plea to? Well, so we know that, well, I mean, he's lied before then. He presented the prescription.
Yeah, it's criminal conviction before.
Yeah, I think the pension is not good.
What the total restitution is?
$500 most likely about 250.
I'd ask the court sanction for October the 14th, and one of them, if you got the drug test, we can pay the next day.
Okay, I'm gonna hold you in contempt for not complying with the order, but I'm gonna give you to October the 14th to purge yourself from it. In other words, if you pay the rest of the $500, appear here on October 14th and we'll have the drug results. If the drug results are confirmed, call me and I'll issue a warrant. Okay, I'll give you the benefit of the doubt. You told him you didn't take it, I'll give you the benefit of the doubt. So you're in contempt. I'm gonna give you 30 days in contempt, and you can purge yourself on October the 14th. In other words, you pay it the rest of the restitution within, and I'll remove the 30 days. You understand what I'm saying? Okay. Let's go back to Luther Connor. Thank you for coming back, counsel. Okay, Commonwealth versus Luther Connor. What do we have here, Mr. Stockton?
And we just have that, she's not gonna be here also on September 15th,
Be here for September 15th, Mr. Connor, for negotiation, and your next court date is October 14th. And both of those are conditions of your bond. You look a little dazed to me today. Did you stay up last night too long, or what's the story? Do what? Went coon hunting. Test this young man here. You take a test, you might want to stay around for this. You can ask him if he wants to make an admission in presence of his counsel before you test him. Now, what about Joseph Craig? Okay. Where is Mr. Craig? Come on up. Commonwealth versus Joseph Edward Craig. 20 CR 0077 and 20 CR 0073. Are you Joseph Craig?
Yes, Your Honor.
Okay, you have you're here today for sentencing with your counsel. Have you had plenty of time to look at this pre-sentence investigation report on a probation parole?
I went over it with him, Your Honor.
You had enough time?
Yes, Your Honor.
Okay. Upon a plea of guilty to the indictment under 20 CR 0077 for charge of obscuring the identity of machinery, he shall receive a sentence of 2.5 years. On plea of guilty under 20 CR 0077 for the charge of receiving stolen property, he shall receive a sentence of 10 years. On the indictment number 20 CR 0077, 2.5 year sentence and 10 years shall run consecutively for 12.5 years. On plea of guilty to indictment number 20 CR 0073 for charge of obscuring the identity of machine 3 counts, you shall receive a sentence of 2.5 years on each count to run consecutively for a total of 7.5 years. On plea of guilty on 20 CR 0073 for the charge of receiving stolen property 2 counts, you shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. Under indictment number 20 CR 0073, the 7.5 years and the 5 years shall run consecutively 12.5 years. The 2 12.5 year sentences shall run concurrently for a total of 12.5 years. Probated for 5 years, you shall receive credit. Defendant shall pay restitution under indictment 73 in the amount of $6,000 to be dispersed in accordance with restitution order monthly rate of $200. First payment being 30 days after the entry of the plea. Have you made that payment yet? The $200?
No, I'm making.
Okay, you need to do that. Each subsequent payment is due on the same date and subject to 5% fee. What's the court cost? $155. You need some time to pay that. $155 court cost.
I paid that.
Okay, well, if that suits you, go ahead and pay the court costs today and your one restitution payment. Now you need to meet with the probation and parole officer there. Okay. Okay. Charlotte Koger. She take the call.
Judge, we may need to finish work out the paperwork on the plea. Yeah, we're not in paperwork.
Okay, just have her sit down and go ahead and sit back down if they're working on a plea agreement, okay? No, just have her sit back there and have her sit down, go back there and sit. Okay,
Mr. Connor admitted to me when we walked through the door that he can be positive for Xanax and Permethrin.
okay, take him into custody. He'll be back up here on, court date will be on October 14th. Except for Ms. Colbert, does that finish everyone else?
In person, yes.
Okay, that's in person. We'll go to the jail. What do you want to do first? To Russell County Jail first.
Oh, me?
How long can I stay in jail till my next court date?
It's,
14.
Russell County Jail, Commonwealth versus Jesse W. Brown.
Yes, sir.
Jesse W. Brown. Mr. Shepard, are you arranged where you need to be?
Yes, sir. Can you hear me?
Yes, the Commonwealth of Kentucky versus Jesse W. Brown, 21 CR 005. Are you Jesse Brown?
Ma'am.
Hey, we're here today for a pretrial conference. What's the Commonwealth have to say?
No, we have the blood results back. We have our expert opinion back. It's been furnished to Mr. Jeff. We just need to trial it. And I would anticipate probably at least 3 or 4 days. And I don't know how much time Mr. Shepard needs to get ready. But I would say sometime in the end of the year, first next year. So,
What do you have to say, Mr. Shepard?
Judge, if we're going to set a trial date, I would ask for it to be out quite a ways. There's still quite a bit on our end that we need to do to be prepared. And I was also curious if the Commonwealth anticipated there being any additional discovery in the form of a black box from either of the vehicles involved in the incident.
I was checking on that. I don't think there were.
Which one of these? Not have it.
But there is all first.
So we don't have it.
Judge, I didn't hear what he said.
I said, I don't think there was, but I'll check and double check. and I'll
Okay.
sure.
What about January the 5th? Is there any district court here on January 5th?
Plan on going next week, if we don't finish.
Well, it's got the 5th, 6th, and 7th.
Okay, that's fine. I would think we could finish 3 days.
I guarantee you we will. Okay, the trial will start on the 5th to the 7th of January. We'll have a pretrial scheduled on November 4th for any pretrial motions. Or do y'all just y'all want to notice if you want a pretrial?
That you can notice if you want. I don't have to have a quick draw.
Okay, well, I won't set a pretrial in, Mr. Sheffield. If you want one, if you want it, have it by November 4th. But that's what I'm saying. November 4th should be the pretrial for any pretrial motion, November 4th, okay? Thank you very much. Ronald Daniels. Are you Ronald Daniels?
Yes, sir.
CR 0033. Your attorney is here.
Yes, sir.
Okay, Mr. Pretrial Conference, what do we have?
Your Honor, I've had some talks with Mr. Stockton. We've reached an agreement with Commonwealth based on the last offer he made. We need time to do paperwork on that. We can do that today, so we can incorporate that. We did it before.
Okay, set this for October 14th. There's been an additional indictment that they worked into your case and part of your agreement. And we'll have you here on October 14th to wrap it all up, okay?
All right, what will that be, Your Honor? Like, is that a trial date or a pretrial conference or?
Oh, it's a plea date. They're gonna wrap it all up, all this stuff into one like that you've agreed to, okay?
Okay, when I was talking to my attorney earlier, they were trying to give me the 180 days and then out on drug court.
Well, now, I don't, wait.
It's what we talked.
He said it's what you talked about with it,
Getting credit.
Okay.
that you'll get the credit stuff, and he'll be in contact with you, and I'll have you back up on October 14th, okay?
All right.
Okay, thank you.
Put your mask back on and sit back down.
Allison Dean. Commonwealth versus Allison Dean, 18 CR 0044 and 21 CR 0047. Are you Allison Dean?
Sir.
Okay, what does the Commonwealth have to say about this? Shock probation hearings?
Your Honor, this is our shock motion.
Go ahead.
Ms. Dean had two cases and we waited basically until the 180 days was nearly all the way up on the older case, 18 CR 44, which she was revoked on back in March. Ms. Dean, I think is someone who has potential. I think the Commonwealth would agree with that statement, but she has a problem and she's got to get.
What about the contraband? Let's go to the contraband thing. She might have a problem, but was she trying to sneak stuff into the jail? Is that what she did?
Your Honor, no, I don't think, I don't believe that was the case. I believe she had something on her when she was arrested.
Well, having something on you when you're arrested is not promoting contraband. Trying
Well,
to take
it
to the jail.
is if I mean, that case has been, that case has been adjudicated.
Well, I know if it hadn't been adjudicated, you wouldn't be making a motion for shock probation.
Correct. We have a rehab bed for her Monday at Sky Hope in Somerset, which is a long-term placement, which also offers the capability to have her stay there even after she completes the program, to stay on staff, and it has the capability to help her find employment there in Somerset or in that area, help her get her on her feet. I think Miss Dean is worth taking a chance on, to give her a chance to get her life straight.
What's it called?
Miss Dean's had a terrible drug addiction for some time. She'll get there and then she'll relapse. I don't think she can ever succeed as long as she lives here in Lincoln County. She's got too many friends, she needs to stay away from the people. I told Mr. Shepherd that when he talked to me the other day. I don't have a power to bank her for Lincoln County, but I do have a power to keep her in jail, hopefully. And if she's going to remain here, I just don't see that she'll ever succeed, even if she goes to rehab and comes back.
Well, she was previously revoked. Is the reason she was there because they set a charge and injury.
And I wrote this thing, I wish she was straightened up, but I guarantee if she goes to rehab and she comes back here to Lincoln County, she'll be in trouble within a year.
Your Honor, can Miss Dean testify?
Well, sure, she can testify. Have her raise your right hand. Raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Your speaker's off.
Yes, I do.
Go ahead, ask her a question.
Go ahead and state your name.
Allison Dean.
And do you acknowledge before the court that you have a substance abuse problem that you need to address?
Yes, sir.
And are you asking the court for the opportunity to go to a treatment center and address that?
Let her testify. Tell me
Okay,
something.
how would you like to address that, Allison?
I just would like to give the opportunity to go to this rehab because it allows me to get established out of Clinton County, which I think that's a big problem for me. I just want to be successful to be present in my kid's life. I do have a bad addiction problem, and I just want to have a chance to be successful and work on it.
Do you have any plan? Obviously, the first step would be going to this treatment program. Do you have any plans beyond that?
I would like for them to help me get established there, if possible, so I wouldn't have to go back to Clinton County and start over there, if possible. That's what I want.
Answer any questions the Commonwealth has for you.
What's the rehab you're going to? What you want to do? You know anything about it?
She can't understand. Get me louder.
You hear me, Miss Dean?
Yeah.
What, you know anything about the rehab that you want to go to?
No, well, I read the paper of it. It was like it just told me like the phases and stuff. And the last of the phase was like helping me get a job, helping me with my kids, getting them back, and helping me get established.
Who has your children? Now your mother?
No, Brad showed it to me.
Does your mother have your children now? Who has children?
My mom.
And what does she say about the rehab? Is she in favor of you trying to reunite with the children at some juncture?
Absolutely.
Okay, well, here's what I'm going to do. The Commonwealth seems to have softened a little bit as far as wanting to give you a chance. This is not a game here, okay? You need to go into that rehab, and I want the rehab to be required to report immediately. If you leave there and you're to report to the Clinton County Jail, if you leave there, you understand what I'm saying? We don't want to have to go over hell and half of Georgia to look for you. And I want it to be a long-term placement. And if you make it through there, we'll take another look at it at some juncture, okay?
Thank you so much.
Mr. Shepherd, or 5 years supervision after.
5 years supervision after the completion of this rehab, okay? Okay, thank you very much. Okay, you'll be on supervision while she's at that drug rehab there. What's the next person?
Amanda.
Amanda.
Right, thank you.
Yeah, Amanda Jewell. Amanda Jewell. Are you Amanda Jewell?
Yes, Your Honor.
This is 21 CR 0075. We're here today for a pre-trial conference.
Your Honor, I think we have an agreement, but we came at it at the last minute and weren't able to get the paperwork done, but in time for today.
October the 14th. Elmer Neal. Elmer Neal. Commonwealth versus Elmer Neal, 15 CR 00109. Are you Elmer Neal? Yes, sir. Okay, we're here on the shock probation hearing. Mr. Shuffett, is this a shock probation?
And Your Honor, I filed this back some time ago.
But Tom Carroll is listed as counsel on.
I filed one. I'm not sure if Tom filed one in addition to.
Okay, Mr. Shuffett, go ahead, Mr. Shuffett, what you got?
Elmer's been, again, this is one that I waited till the very end. So he served as a complete 180 days just about before I filed it. And Elmer, when's your pro eligibility?
This month.
November 2021.
This month.
This month.
Yeah.
So, if the court wanted to continue this to see if he made parole, I think that would maybe be beneficial to Elmer if he did make parole.
I have no objection to take this under advisement. Take it under advisement, see if he makes parole. Okay, is there anybody else there at the Russell County Jail?
That's all we had listed on our docket from you all, Judge.
Thank you very much, and good luck to y'all during this time, okay?
Thank you too. Elmer, put your mask back on, please.
This is that Adair County sentencing that we have.
Adair County? Adair County?
We're here, Your Honor.
Okay, Chris Belcher?
Yes, sir.
Okay,
And I don't know about the cost.
and
Mr. Wright's.
is Mr. Wright on the line?
Judge, this is Lacey Andrews. I'm here for the Commonwealth.
Okay.
This.
Okay, this is Commonwealth of Kentucky Adair Circuit Court meeting on Zoom. Indictment number 20 CR 00120. Are you Christopher C. Belcher?
Yes, sir.
And your counsel is on the line, Ms. Costello. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman rather should not be sentenced?
No reason he should not be sentenced, Your Honor. The one update we would ask to the report, it was initially done when we believed his sentencing would be August 10th. So his jail credit would just need to be updated to reflect from August 10th until today.
Okay, just make sure probation and parole does that. And if you have any objections, you can bring it back up with the Commonwealth. Upon the defendant's plea of guilty, the defendant shall receive 10 years on assault in the second degree and 2 years on tampering with physical evidence to be served consecutively for a total of 12 years. There will be forfeiture. Court costs the amount of, we don't know what the court costs will be. But I'll just make the court costs $155. That's what we would charge here. And he should pay that $30 a month, starting 30 days after his release. This shall be consecutive to any other sentences he has been imposed on it. Is there anything else to bring up in this court? If you'll.
Not today, Your Honor. No.
No, Your Honor. Thank you.
We drafting the judgment?
It's Ms. Andrews. I don't know if they do it in the prosecutor's office.
The prosecutor's office there usually draft the judgment and submit it.
We don't judge, but we can do that.
But we can do it. We'll go ahead and do it.
You want us to do it?
No, we'll do it here.
Okay, thank you, Judge.
Okay, thank you very much.
That's all I had before you today, Your Honor. May I be?
Yes, thank you. He wasn't sentenced to time served. He was sentenced to the 12.5 years, right?
12 years, yes, Your Honor.
12 years, yes.
Okay, thank you. Pulaski County, are you on the line?
Let's see, and I sent an email.
Pulaski County? Somebody needs to contact Pulaski County for us. Can Commonwealth Attorney's Office here do that? No,
Person might be able to come.
Carson, can you do that? KCIW, are you on the line? KCIW.
And I'm not sure, I think this might have been a pro se short probation motion. I didn't receive the motion when I reached out to counsel. He said that he had not filed anything, so he just assumed she had filed it.
Who was counsel?
G. George Bertrand. He said he had not been contacted by
Did you
her,
check the file and see what?
that he had filed one previously that had been denied, and he thought maybe she might have. Again.
Who filed it? Do what? Okay, it was a pro se motion for shock probation. What I'll do is we'll send an order up for him to connect us on October the 14th. Since these pro se things, a lot of times they don't know to notify the institution to make the arrangements. So we'll take that in consideration and take it on October the 14th. Wayne County Jail. Wayne County Jail.
We're here, Judge.
Thank you very much. Ashley Barton. Commonwealth versus Ashley L. Barton, 19 CR 0069. Are you Ashley Barton?
Yes, sir.
What are the last four digits of your social security number?
2957.
Mr. Sheffitt, this is your client, I believe.
Yes, Your Honor.
Okay, we're here on a revocation hearing. Is that correct, Mr. Stockton?
Yes, Your Honor. She was, had a 7-year sentence on trafficking and tampering with physical evidence. She reported one time in May to her probation officer, and then she was gone. That's the basis of the violation. We did report that.
Your Honor, I think that's incorrect. I think she actually started probation earlier than that. The testimony will clear it up, though.
Mr. Payne, you want to come up and be sworn, or you need to wait for a second?
I need to wait, I'm gonna go and click with plastic.
Okay.
Thank you. You said that to C. Arnold at Pulaski County. What was it again? Are you there? What's the address? PulaskiJail.com. All right, we'll get it to you. Richard Smith, yes. All right, thank you.
I sent it to 2 different addresses.
Okay, this is Ashley Barton. You raise your right hand, you swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
State your name. This is probation parole officers about to testify. State your name, sir.
Officer Carson Payne with probation and parole.
Okay, Mr. Stockton.
Yes, Mr. Payne, it's Mrs. Barton was placed under supervision when she was probated, is that correct?
Yes, sir.
Okay, now, it doesn't do any good for both of you to be away from the
Yes, sir.
microphone, okay? You just stay behind the microphone.
Yeah. It was at some point in time, was her probation transferred to another officer?
It was transferred to District 16 now.
Okay, and did you receive a violation report from that officer?
I did.
And what was the problem?
She absconded from probation.
Okay, what's the last report? Did she report?
On 5/27, this report, 5/27/21, she reported as directed and was given the next report date of 6/23. 6/23, she failed to report. 6/29, the officer left a message with Miss Barton's listed contacted voicemail report for her to report the next day. She failed to report the next day. On July the 2nd, left another message for her to report on the 2nd. She did report on the 2nd. On the 6th, he spoke with her mother, and she reported that she believed Miss Barton had checked herself into the mental hospital. Miss Barton's mother agreed to deliver report instructions when Miss Barton called her next and for her to sign and release information for probation and parole. This officer left reporting instructions for 7/9. She failed to report on 7/9. On 7/27, he left a message on the voicemail of her mother and did not receive a call back. On 7/29, he mailed a letter directing her to report on 8/5. On 8/5, she didn't report. He checked with all hospitals and Justice Exchange, showed that she was not incarcerated or in hospital in the Louisville area, and requested a warrant on 8/5.
When she was picked up, was she located here in Clinton County or what?
Yes, on August the 27th, the warrant had been out roughly 22 days. She was arrested by Wayne Glover in Clinton County. And I spoke with her at the jail the following day, and she advised that she had used a Klonopin approximately 2 weeks before being arrested.
Now, District 16, is she being supervised in Louisville? Or
Yes,
Okay.
she was living in Louisville.
Supposed to be living. Now, she was actually placed on supervision sometime before May the 27th of 2021.
She was replaced on supervision May the 6th, 2020.
Okay.
I'm sorry.
Mr. Sheffitt, would you like to inquire?
Yes, sir. Do you have any notes from the Jefferson County officer regarding her conduct between May the 6th of 2020 and May the 27th of this year?
All I have is the violations.
Okay, but there are no violations listed during that time.
The first violation I had started when she failed to report on 6/23/21.
Okay. But you don't have any additional information from the probation officer prior to that?
No, sir.
Okay. I've got no further questions for Mr. Payne.
What do you have to say, Mr. Stockton?
Well, I think we probably need to call Miss Barton.
She's already been sworn. State your name, ma'am.
My name is Ashley Barton,
Okay.
and I'd like to apologize and say that I am.
That's you can get to that, but answer questions at first me and then Mr. Stockton, okay?
Yes.
When did you begin probation approximately?
I was released from Russell Springs County Jail in May, and I believe I went to a long-term treatment, which for 90 days. I reported that whole 90 days.
Where was that treatment, that program at?
That was in Louisville, Kentucky, at the VA.
Did you stay in Louisville after you completed treatment?
I did. I resided in Louisville. I still have a residence in Louisville at a sober living home, an Oxford House. I obtained employment there immediately, from rehab, and
where were you working at in Louisville?
I worked at McAllister's Deli, and I was also in a program that I was referred to from the rehab. It was a career development program, which I did obtain a certificate in just in June, which was even after I absconded. I still completed that program, and I am awaiting job placement for it, but everything's so hectic with the COVID in Louisville that a lot of things have been put off.
Okay, so you admit that you abscond starting, I guess, in June of this year. So tell the court what happened.
I can reassure the courts that it was not a relapse. I'm very active in my recovery. I still do my meetings, and I live in a sober living home, and my program also did random drug tests. My absconding was due to, I can only say, to a mental health issues, which I previously have. I was on meds in rehab and in jail. And upon getting out, because of the COVID, it was so hard to get into a doctor and do a follow-up to be prescribed anything. I had touched base with my PO on this. He knew, he was very aware of this. The day I absconded, I had just tried to check into a hospital 3 days prior to that, and they would not take me unless I was a harm to myself or others. It kind of spiraled into maybe just a temporary, I don't even know what to call it, but it was a panic mode. And I believe that's when my mother may have called that month. I could barely even speak to her.
Do you have any mental health diagnosis
Yes.
that's been given by a professional?
Yes, sir.
What are they?
Okay, I have been medicated and diagnosed with severe anxiety, social anxiety, and manic depression. My progression's been so well on this probation, and it's due to my sobriety. And my PO officer, he was amazing. And I really failed to use him as the crutch that I should have at this moment. But like I said, my anxiety it overtook me. And the meds that would have been in my system, I'm not even sure if they still would have been. They were meds that were carried over from a prescription I had anyways. It took as needed. And I just chose not to use it so much because I've been remained focused and active in my recovery.
Right.
But
what were you doing in Clinton County when you were apprehended in August?
Okay. I did have permissions to be in Clinton County on the weekends. My PO knew this. Where even though I'm waiting on my job placement, which I'm trying to get it in Somerset, that area, close to home, but I have bought, while on probation, since I've maintained my jobs and everything, I saved up, I bought some land in Albany. So he knows I've been coming there on the weekend and fixing up a place. And that was my plans eventually to be moving there. So I had weekends, so that's kind of why I was there. But of course, the absconding makes it all kind of.
And that's what's on my mind, and probably on the prosecutor and the judge's mind as well, is why, if this probation officer was obviously a good influence in your life,
Absolutely.
Why not go to him for help, or at least a jumping off point in terms of maybe he can put you in touch with other people.
And he absolutely did. I did touch grounds with I checked in with him for almost a year. So we had a relationship, and he definitely was familiar with kind of what was going on with me. But as it was getting worse, it was harder for me to kind of open up to him about it. And why I didn't, I can't even answer. And I am so apologetic over it and ashamed, actually, because he was so helpful to me, and he really did make me feel comfortable, and he was such an aid during this. And I apologize to him from the jail call up here. I really wish he was here to speak on my behalf, and he does too. I don't know why, I can't explain what happened there, but once I missed it, it was like it got harder and harder to try to contact him and to and even to turn myself in. That was obviously my plan. And my anxiety just overwhelmed me. And then I just can't even explain it.
If the court were to extend your probation or release you, what would be your plans?
I've heard all I need to hear. Mr. Stark, you want? I'm gonna revoke here. We've used every excuse known to man or woman except my dog ate the homework. And obviously, there's absolutely no excuse for what you've done and to abscond, and we cannot allow that. So I'm going to revoke it. I hope you get help. I don't doubt you have problems. I hope you get help, please. And they have help for you in the institution. Okay, Benjamin Claywell. The purpose of arraignment. Are you Benjamin Clable?
Yes, sir.
This is 21 CR 0088. What's your year of birth, Mr. Clable?
You what, sir?
Your year of birth, sir?
Oh, 10-3-86,
Last four digits of your social security number.
2415.
You're here for arraignment. Your attorney, or you're represented by public advocacy. Mr. Shuffett, is he one of yours?
Yes, sir.
Okay, you have two indictments here. 21 CR 0088, the grand jury of Clinton County has returned you an indictment charged with reckless driving, driving unsuspended, fleeing or evading, and being a persistent felony offender. And 21 CR 0089, the grand jury's charged you with trafficking and controlled substance, first degree convicted felon in possession of a handgun, possession of marijuana, drug paraphernalia, and being a PFO. You understand those charges?
Yes, sir.
Okay, we'll get copies of those indictments. The sheriff's office will bring them back to you. Mr. Bailiff, you take these indictments back to, or the sheriff can either, if you want. Take them back to Mr. Shuffett back there. Mr. Shuffett, you acknowledge receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, you want to set up a pretrial on the 15th? I mean, rather a conference day on the 15th and a pretrial?
That's fine, Judge. I would also like to address Mr. Claywell's bond.
Okay. Go ahead.
I guess I'd like to start with what it is, what is his bond?
Ben, what is the bond on these two cases?
Judge, same bond covers both cases. It's 5,000 cash or twice property with a curfew with your standard exceptions.
All right, I think I've heard Mr. Claywell on various cases over the years. He's failed to appear, especially in NCIC.
Home incarceration, I think, was on one of my conditions on the bond. It was 5,000 or 2 times property. I made a $50,000 property bond in district court, and they told me that it would hold over in your court, sir, but I don't know whatever happened.
There definitely needs to be a secured bond.
So a $50,000 property bond with an ankle bracelet?
Yeah, I think that's very, and not go anywhere. And he doesn't need to be out.
Well, let's just have a hearing on this then. The Commonwealth has reservations. You need to schedule a bond hearing on it.
Your Honor, is it my understanding that the current bond is 10,000 property?
5,000 cash or 10,000 property and an ankle bracelet.
Well, I would ask the court to allow the district court bond to roll over. It's a $50,000 property bond. It's already been.
I'll allow it to roll over if you want to put an ankle bracelet on.
Yeah.
No objection to
Ankle
that.
bracelet, and he's under a curfew too. Home, work, church, the doctor.
That's what I was trying to do, sir. Get out so I could go.
You can do that. You can do that. Okay. $50,000 property bond, ankle bracelet, home, church, work, doctor.
Your Honor, sir. I done posted the bond, so will that
You're gonna put an ankle bracelet on it, and if the bond is good, make sure you look at the bond. We're checking the file.
Okay, thank you, sir.
You looking for his file?
Ben, what would be your address if you get released?
I can't think of what the address is out there right now, but I could probably call and get it from here.
When you get released, will you call with your phone number and leave your phone number and address, okay?
Yes, sir.
Because we're gonna get some discovery and we need to know where to send it.
Okay.
And they're giving you 2 court dates, okay? Next Wednesday, September 15th at 1 in the afternoon, and then October
We're
14th at
checking
9
the
in the
bond
morning.
right now. We're checking the bond to make sure the bond's still filed, hadn't been released.
So if you get released, make sure you're here those days.
Yes, sir.
I also need an address before he can be released, specific address where he's gonna be under this curfew at.
Okay, sir.
He's got home incarceration and a curfew on top of it. Well, sometimes if I just said ankle bracelet, I don't remember what I said in home incarceration. I thought you just go where you wanted to. We had that, went into that casino down there. Remember that?
Doesn't mean they don't.
Yeah.
They're not supposed to.
That's what it'll have to come to.
People don't want cash loans, that's fine. That's the issue. Brings somewhere in the state. Say where.
There'll be 2 places.
We run the federal system on bond and Virginia system on truth and sentencing. That's all, it ain't, you know, problem.
And Judge, I've been faxed a positive COVID test on Lloyd's men. The test was conducted yesterday. From the Family Medical Center. Oh, no, I'm sorry, it's from the med
Sure.
center. It's from-
I was at the ER last night with another individual.
Very sweet.
He was sick and tested positive.
So we withdraw the bench warrant.
Withdraw
Withdraw the bench warrant then. Did you hear that?
and put that in Lloyd's Smith's file.
Here's his bond. This is a property bond. Did they have all the information necessary on a property bond?
Young David Gray. And I wouldn't be particular about this, but every time Mr. Displayo has to encounter the law and punishment. Every time. And we're prepared to put on this.
The guy that posted the bond for me, I'm working for him and everything, and I'm just trying to straighten my life up and do what's right.
Is there a deed in front of us?
Yeah, there is a deed and there's a DBA report that says the value of the amount.
$50,000 bond?
Yes.
Okay, $50,000 bond in home incarceration with an ankle bracelet with the exception, and he can have work release on that. But I want you to give us a valid address where you're gonna be at before he's released. I want a valid address. And then when you're going somewhere to work, if you're working for Mr. Gray or someone, you need to report in the pretrial where you're gonna be every day. If you got one location, I don't want you out, as I used to say, over Monroe County, bombing around. Do you understand what I mean?
Yes, sir.
Okay, thank you very much. Bill, Joey Duval. Joey Duval.
Yes, sir.
190030, Commonwealth Kentucky University, Joey Duval. Are you Joey Duval?
Yes, sir.
The last 4 digits of your social security number.
6376.
Okay. We're here today on a motion to revoke
Your Honor, Richard,
probation.
5 years sentence on receiving stolen property. And I just sent him to claim what he testified.
Okay, Mr. Payne, you want to raise your right hand? You swear the testimony you're about to give is the truth, whole truth, nothing but truth. Okay, go ahead. State your name with whom you're employed, what the best.
Carson Payne, probation and parole, District 20.
Mr. Payne, how long has Mr. Bidwell been on supervision?
He was granted probation on August 8th, 2019.
And this is his second motion to revoke probation. He's had previous violations, is that correct?
Yes.
Now, at some point in time, was his probation, he requested to move to Ohio.
On September the 5th, 2019, a revocation hearing was heard. Subject was ordered to serve an alternative sentence to see if ICOT's transfer to Ohio was accepted. On October 17th, subject was released from custody and his probation was transferred to Ohio.
Okay, what's happened since then?
He's had multiple arrests in Ohio. And subject was being supervised from Ohio. He comes to Kentucky on July the 17th, 2021, and was arrested for failure to appear district court warrant out of Kentucky. I spoke with his officer at that time, and they advised he did not have permission to leave Ohio. Subject was arrested again on 8/31/21. And on August the 24th, a warrant of arrest complaint was issued for subject for criminal trespassing while he was in Kentucky. Then after the criminal trespassing and the officer said he didn't have permission, we requested a warrant for him to be in Kentucky without permission and also with him receiving new charges. This officer spoke with subject when he was arrested and asked if he could clean on drug screen. He advised yes. Subject then advised he would not produce a drug screen for this officer due to this officer being out of Ohio. Subject advised he was in Kentucky taking care of his dying mother, and all this officer was worried about was a drug test.
So he refused to give you a drug test because you weren't his probation officer?
Yes, that was his exact words.
Okay, so he wasn't in Ohio where he was supposed to be?
No, sir.
He didn't have permission to leave Ohio?
No, sir.
And how many arrests did the charges, did he have in Ohio, and you have those? Before he left?
At least 3.
Okay.
He was arrested by the, I don't know how you want to say that, Jesse.
Fleetwood Police Department.
Fleetwood Police Department on 5/17/20. By the Miami.
You held the charge for it.
Theft, shoplifting. He was arrested by Miami County Sheriff's Department with traffic offenses, driving under DUI suspension. And there were one more. And he was arrested by the Butler Police Department and charged with theft at Walmart, possession of drugs, carrying a concealed deadly weapon, and improper handling of firearms. On June 2020.
And he was charged with criminal trespass here in Lincoln County?
Yes.
Do you have the citation on that?
I do.
What was the allegation?
The warrant says the Philip Lynn Blackman states that on 8/21/2021 in Clinton County, Kentucky, the above named defendant. On Saturday night, there was a dumpster fire at the Pines of Cumberland. Officials noticed a flashlight in vacant apartment upon arrival. Further investigation revealed defendant's wallet, phone, and pack of cigarettes in the vacant apartment.
Okay. Now, since he's been out of absconded from Ohio and came down here, you don't have any knowledge of what's been stated?
No, sir.
Okay. Nothing further.
Mr. Sheffield, would you like to inquire?
Mr. Payne, have you spoken to the Ohio officer or just exchanged paperwork?
We just exchanged paperwork through the system called ICOPS.
Okay. In your report, it says on August the 11th that the Ohio officer spoke with the subject and he had, at that point, he had 2 weeks to return to Ohio.
Yes.
Okay, so
I think it was, what day was that?
August the 11th.
And he advised he would be returning within 2 weeks. On August 11th.
Okay, and she was, I mean, I'm guessing that officer was, I mean, she wasn't asking for a warrant or anything like that at that point, right?
No, but he had been here since before July the 17th.
And then he was arrested on a trespass charge on August 24th.
That was the day the warrant was requested. And he was arrested on August the 31st.
Okay. But you haven't had any contact with him other than the interaction at the jail here in the last week or so, right?
No, sir.
Okay. No further questions.
Just to clarify a few things on Ray today.
I'd like to say something to Mr. Sheffield, if any way possible.
You have a chance.
Look at your notes. It looks like the Miami County Municipal Court, he was found guilty of theft in that case number, is that correct? Give him a 180-day sentence with 165 days suspended.
Yes, sir.
He also was convicted.
You need to speak up a little bit more.
He was also convicted in Vandalia Municipal Court of theft on June 16th, 2021. Is that correct?
Yes.
Okay. And then the other charges are still pending as far as you know. Okay. Nothing further.
You have anything else, Mr. Sheffield?
If we could call Mr. Duvall.
Okay, sir, will you raise your right hand, please? Swear the testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
See.
Okay, Joey, go ahead and state your name.
Joey Duval.
Okay, and how long have you been living in Ohio?
I've been living in Ohio for 3 years now.
Okay, who do you live there with?
Me and my wife.
Any kids?
She is actually pregnant right now. She is due March the 22nd.
Okay, what is it that brought you back to Clinton County?
My mother, I got a phone call one night stating that my mother was in the ICU intensive care unit. At that time, I rushed down here. I contacted my officer, I think the very next day, and let her know. I went to jail in Clinton County over an old warrant. Once I was released, I contacted my probation officer. She told me there's going to be consequences behind it. She gave me a 10-hour extra duty sanction. She actually told me I could do my 10-hour sanction in Clinton County because she had no problems with me. Told me I could do my 10-hour sanction in Clinton County. And then later she called me back and told me that when I got back up there, I could do my 10 hours up there.
Okay. Now, when was that conversation?
That conversation was probably 3 days before I was arrested in Clinton County.
Well, when was that?
I really don't know the date on it, sir.
Okay.
2 weeks ago.
You were arrested, according to Mr. Payne, you were arrested on this criminal trespass on August 31st.
Well, okay, yes, and okay, then August the 28th is the day that I spoke with my officer, and she sent me a text message, told me that I couldn't do my 10 hours there in Clinton County, my 10-hour extra duty, that I would have to wait till I got back to Ohio to do it. She asked me when I was going to be returning. I told her I really didn't know at that time because my mother is still in ICU. As we speak right now, she's still in ICU.
Okay. So did you ever get explicit permission from your probation officer to be in Albany?
Yes, I did. After when I called her and let her know that I was down here and everything, that my mother had called, I got the phone call in the middle of the night, and she told me that, okay, she gave me 1 month, and then told me that after I came back to Ohio, that if my mother was still in critical condition, she would actually give me another month pass to be in Clinton County. Her name is Catherine Weber.
Okay. And your probation officer in Ohio was aware of these charges in these different jurisdictions, Pequot, Butler, and Miami County?
Yes, sir. It was actually she told me to stop hanging around the people that I was hanging around with, because after they reviewed the tape and stuff, I wasn't doing anything. She told me to just quit hanging around people I was hanging around with.
Okay.
And gave me extra duty on that too. I mean, I was done sanctioned for every bit of that. I mean, right now, I think our only problem is me being in Clinton County. They don't want me in Clinton County. And if that's the case, as soon as my mother passes, I'll be going right back to Ohio. If released today, I'll be going back to Ohio if that's what's wanted. I mean, I just would like to be with my mother when she passes. I mean, that's all I'm asking is to be with my mother when she passes.
Well, do you know what diagnosis your mom has?
I really do not know because my mother is not letting anyone know. I know that about 3 weeks ago, she was given, they gave her a treatment.
Okay, all this is double hearsay. So you have any other questions you want to ask him? He might be.
Okay. What would be your plans if released by the court?
If the courts would release me today, I would go back to Ohio if that's what's wanted. I mean, I'd like to be with my mother in case she passes. I mean, she has no one.
It's repetitious. Okay, I'm sorry about your mother's situation.
I understand that, sir. If I'd like to go back to Ohio and
wait. Okay, you have any other questions?
No, Your Honor.
You want to make a statement, Mr. Stockton? No questions. Okay, you want to make a statement?
I'm sorry too for Mr. Duval's mother, and if he had lived a different type of life, he wouldn't be in this type of situation. He wouldn't be worried about whether he could be. But the way I counted this, he had at least 4 different criminal cases in Ohio, 2 he's been convicted of. And then he comes down here, he gets another arrest, and then when Mr. Payne wants to drug test him, he has the arrogance to refuse. So he has contempt for the law, he has contempt for the court system, and I don't see point to anything with revoking at this point.
I did not do anything to.
Second.
Joey, that you don't respond.
Go ahead.
Judge, you know, I can't sit here and say there hasn't been some violation. These charges are obviously violations. Now, the trespass is pending in Clinton County. He was just arraigned on that. So I don't know where that case is going just yet. But the ones in Ohio, obviously, his probation officer in Ohio was aware of those and dealt with those.
Well, he says she was. I don't know.
I mean,
I don't know that. His testimony he gave was not admissible. There wasn't any objection to it that much. But we don't know what she said or what she did. We have no official record of that. Go ahead.
Well, she certainly did not ask for a warrant or ask to file for revocation upon conclusion of the charges in Butler, for instance, which was the last of the 3, or Vandalia, which was the last of the 3. I would ask the court to sanction him here in Clinton County for a period of time, and then allow him to return back to Ohio to complete his probationary period.
How much time does he have on the shelf? How much time does he have in jail then?
I know we've got at least 70 days, not counting what he had to see.
Well, how many days does it take before you'll be eligible for parole?
You have to have 9 months or 270 days in 5 years.
we have a copy of his other criminal record? This is my book.
If it's attached to the motion,
I think it's a booklet.
it'd just be easier to find.
Okay, okay, there it is.
Just have them stay on there. We'll come back.
Well, he admitted to drinking. He was positive for methamphetamine. Had a misdemeanor arrest and then multiple things in Ohio.
Because I'm looking at about 130, 135 days, roughly.
Yeah, I think the best thing for this gentleman is to wait to make parole, and that way he can be outside of the control of this court. So what about his other charge? Do you have it up here or?
Well, we read the citation.
Yeah, I mean, so it wasn't attached to a felony though. What are you gonna do about his misdemeanor charge, Mr. Sheffield?
Well, Your Honor, I'm not sure just yet. He was just arraigned on that yesterday, and I haven't even had a chance to look at the citation yet.
Well, anything he's gonna get will be merged with this sentence.
Would there be any way, sir, would there be any way that you could help me and send me to a drug rehab?
I'm gonna revoke you, and they've got they've got facilities there, and then they can take care of your misdemeanor and clean the slate for you. That'd be the best thing to do, and then get this over with. Okay, thank you very much. LaDonna Kempton. LaDonna Kempton.
Again, I got Duval coming back out.
Commonwealth versus LaDonna Kempton, 18 CR 00103. Are you LaDonna Kempton?
Yes, sir, I am.
Okay. What are the last four digits of your social security number?
422.
Okay, we're here on a probation revocation hearing. What does the Commonwealth have to say?
Has a 3-year sentence on possession. My understanding is she was going to stipulate, she's already got 485 days guilty.
Is that correct?
Your Honor, my conversations with LaDonna as of yesterday, and a message I got as of yesterday afternoon was that she did want to stipulate.
Okay. Is that correct, ma'am? You want to stipulate to your violations?
Yes.
Okay, I'll accept your stipulation and revoke it. Good luck to you.
Oh,
Barbara Neal. Commonwealth versus Barbara Neal, 20 CR 00080. Are you Barbara Neal?
yes, sir.
Revocation hearing, what does the Commonwealth have to say?
On possession of controlled substance. She was terminated from the special report. It's my understanding she wishes to stipulate.
Is that correct, Mr. Sheffield?
I couldn't quite hear him, but I think what he said was that she was going to stipulate.
Yes.
That's correct.
Okay, I stipulate and do a revocation. Good luck to you. Okay, Marazankia Sunshine Neal. Yeah, this is 20 CR 0052, Miss Neal.
She had contracted controlled substance first degree offense, and she was positive for meth and admitted use of alcohol. Mr. Payne wanted to send her to treatment, the detox program, she refused, and she's unwilling to go to treatment, so I'm asking for.
Mr. Sheffield?
Well, Your Honor, I think Mr. Stockton and I had a conversation about drug court. I couldn't tell if he said drug court or not.
He said that he offered to consider some kind of treatment, which could include drug court, and that she refused.
Well, I don't think that's correct. I think
Tell me
maybe
what
at
is
some
correct.
point.
Tell me what is correct then.
Well, I talked to Miss Neal earlier in the week, and I think she was going to do drug court unless she's changed her mind between then and now.
Ms. Neal, are you willing to do drug court?
Sir? Yes, sir.
Okay, well, I'll sign the referral. They'll come over, evaluate you. And if you pass and get admitted, we'll let you out and give you a try, okay?
Thank you.
Okay. Is there anybody else there in Wayne County?
I think that's got them, sir.
Okay, I'm gonna take a short break.
Is Austin Reed not there?
He's gone to a dentist appointment, actually.
Can I speak to Brad?
Who said that?
Ashley Barton.
Yeah, on Austin, Judge, if we could take up Mr. Reed's case.
He's not there, is he?
He went to a dentist appointment apparently.
He's not
but-
on the docket.
Yeah, I believe he is, or he should be.
We checked on him, was told he wasn't on the docket, so we sent him on to his appointment.
Okay.
What was the deal? What's the deal? on
Well,
this?
there was a revocation motion. It was noticed, I guess, for August 12th, and then he's been picked up on it. He was actually present on August 12th in person, and then he was arrested on August 17th from a warrant from it. I wasn't sure exactly how that unfolded, but I had talked to Jesse about drug court for him as well, and he had been in agreement with that if we could.
Mr. Stockton, you listen to this?
Yeah.
Is there any way to address the judge again?
No, at the moment, they're discussing something else.
Mr. Stockton, what do you want to do about this individual that's not on the docket that they're talking about? Well, I mean, yeah, well, we'll just bring him back up on October 14th. Yeah, I'm gonna take a quick break and go down and meet with the grand jury. I'll be right back up here to take care. Have we gotten a hold of Pulaski or KCIW yet?
Pulaski's on
Yeah, well, let's do this Pulaski thing so they don't have to hold here.
there. Casey, I didn't continue.
The KCIW case is continued to next month. That was the one where
Pro se.
Rose Day, it's continued to next month. Pulaski, are you on there with Richard Smith?
Yes, sir.
We're finished with Wayne, is that correct?
Yes.
Are we finished with Wayne? Okay, Wayne can be released. Thank you very much. Pulaski, we have a Commonwealth Attorney versus Richard Smith. Are you Richard Smith?
Yes, sir.
Last four digits, your social security number 2922.
Yes, sir.
Yeah, this is 18 CR 0061, probation hearing to revoke. What do you have to say, Mr. Stockton?
Your Honor, if you want to stipulate, that's fine.
You need to come up here where we can hear you.
We've got a case that we're trying to take to the grand jury. We need some information from Deputy McGuffin on the victim and what was stolen. We're on the burglary case.
So you want to bring this back up
So we can get this, getting the data.
on October 14th?
Yes.
Of course, you won't have time to take it in front of the grand jury by
No, it'll
then.
have to be next month. It was the grand jury.
Well, so when you want it back?
He's serving alternatives.
Okay, so we're scheduling for November the 4th? November the 4th. Thank you very much. Thank you, Pulaski County.
Thank you, sir.
Okay, now we got one case to hear here. Is that right? Is that what we got left? Plea on Ms. Cober. Would you bring her around here? Is that the only one we got? Oh, God. Okay, I'm gonna take a break here. Have her seat. I'll go downstairs till Tom gets okay. Okay.
Yeah. I do. Oh, I was gonna say, instead of giving more NTI days, the Senate does away with the announcement.
Zoom was for the jail cases.
Yeah.
I've not get quarantined again.
Who's that Charlotte Coger play? I guess it's up there.
We have the paperwork.
I'll go up there. I'll go up there on that one. See what we're doing now.
Yeah, Mr. Coleman's trial. Let her stand behind the podium. So we can pick it up. This Commonwealth Kentucky versus Charlotte Coger, 21 CR 0061. Are you Charlotte Coger?
Yes,
Okay, what are the last four digits of your social security number
8293.
and your year of birth? Your year of birth.
Oh, 52956.
Okay, thank you. I understand your attorney has told me that you wish to enter a plea today. Is that correct?
Correct?
Are you currently under the influence of drugs or alcohol?
No.
Okay. Are you the same person named in indictment number 21 CR 0061?
Yes.
Is your judgment impaired today in any way?
No.
Have you had plenty of time to discuss this matter with your attorney, and are you fully informed about your case?
Yes, sir.
Okay, you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, you have the right to know the right to go over those. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand that?
Yes, sir.
By entering a guilty plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept their recommendation. Prior to accepting a recommendation, I will wait the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and to proceed to trial. Well, Mr. Stockton, can you come up here and just move to your left side?
Yes, Your Honor, it's a pretrial diversion. The charge will be amended so she can be granted pretrial diversion. She felt unlawful taking under $10,000. 5 years pretrial diversion, 5 years pay restitution amount of $20,256.23. $10,000 due within 30 days from the day, an additional $5,000 due within 180 days, and the remaining $5,256.23 due within 365 days from the day's plea. All that will be subject to 5% purchase fee. There will be restitution orders to the Clinton County Industrial Authority, which may take that to. She'll receive any credit for time served, and she'll have a $1,000 fine to pay also. And will remain under supervision of all fines, costs, and restitution paid.
What are the court costs in this case? $155 court costs. Is this what you agreed to?
Yes, sir.
A pretrial diversion means that if you successfully complete the terms of pretrial diversion, your case will be dismissed, pretrial diverted, and you will not be a convicted felon. However, if you fail to meet the terms of pretrial diversion, I will have a pre-sentence investigation report done, and you'll be a convicted felon, and we'll do the sentencing at that particular juncture. If you ever had a felony after that, then it can be enhanced under persistent felony offender law. Do you understand that?
Yes.
Okay. Now, knowing your constitutional rights, I've explained it to us, it's still your desire to give up those rights and go ahead with this pretrial diversion agreement. Okay, is that your signature on the restitution order and the pretrial diversion order?
Yes, sir.
I'll accept the pretrial diversion order. I'll sign it, accept the plea, And you'll still need to give certain information to the probation and parole officer over there. Okay? You need to turn around and show the probation and parole officer. Okay, thank you.
Okay, I'm back on.
On that 10-14 plea date on Daniels, what time is that?
9. Everything's at 9 over here on court day. I know I've been.
David Cross's house, 6 years old.
Okay, let's go to the Clinton County Jail. Commonwealth of Kentucky versus Billy Dean Amonette. Are you Billy Dean Amonette?
Yes, sir.
Okay. What are the last 4 digits of your social security number?
4269.
Okay, we're here on a pretrial conference. Mr. Commonwealth Attorney, what do you have to say?
I guess we need a negotiation day, Your Honor. We've not had one. We had to get him back here in our jurisdiction.
And we need to add 20 CR 93 whenever we set it, just to officially get that on the docket as well.
Yes.
Okay. What date do y'all have for negotiation on this thing?
September the 15th at 1 o'clock.
Okay, and then the next court date's October the 14th. Okay, thank you very much. Commonwealth of Kentucky versus Stanley Catron. Commonwealth versus Stanley Catron, 21 CR 0097 and 21 CR 0084. And we have in 97, we have an arraignment.
Your Honor, it's an information,
I'm
so
looking
it'll be
at
a
it.
plea as well.
Information indictment, 2 counts. The information indictment by agreement is added to the additional charge of possession of controlled substance, first degree methamphetamine, and possession of drug paraphernalia. You don't want to take this back to Mr. Sheffield. You acknowledge receipt of the information, Mr. Sheffield?
Yes, Your Honor.
Okay. And y'all have a plea agreement?
Yes.
Yes, Your Honor.
Your attorney has told me that you wish to enter a plea today, Mr. Catron. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 0097 and 21 CR 0084?
Yes, Your Honor.
Is your judgment impaired today in any way?
No, Your Honor.
Have you had plenty of time to review the information about your case and you feel like you're fully advised?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. I need to read you those rights before I can accept a plea. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented with counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and have a right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea today, you give up all those rights. Now, is this a felony plea? One of them is a felony plea, right?
Yes, Your Honor.
Yeah, I may consider the Commonwealth's recommendation. I may apply any range of sentence allowed by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await pre-sentence investigation board done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, Mr. Catron would plead in 21 CR 84 to operate in a motor vehicle, no insurance, second offense, that'd be $1,000 fine. Also in 21 CR 84, it would be a DUI second. He'd have a $300 fine and cost. Also, he'd have the minimum jail time. It's not in there, but it's like 4 days, I think. Also in the charge of 21 CR 84, he'd have possession of controlled substance, first degree, receive a sentence of 2.5 years. In the information indictment, 21 CR 97, on charge of possession of controlled substance, first degree, he'd receive a sentence of 2.5 years. Those 2 felony pleas would run consecutively for a total of 5 years. He would be probated for 5 years, supervised. He would receive credit for time served. He will pay fine and costs at the discretion of the court, obtain gainful employment, pay and be under supervision until all restitution fines is paid. And also, I think it needs to be in there to be evaluated by the SSC.
Is that what you agreed to, sir?
Yes, sir.
Has anyone offered you any recommendation or benefit for any of this plea, or are you pleading guilty because you are guilty?
That's because I'm guilty, Your
Honor. Knowing your constitutional rights as explained to you, is it still your desire to enter a guilty plea and allow the court to fix your punishment as permitted by law?
Yes.
Now, do you understand that by entering a guilty plea here on this felony charge, any future convictions could be enhanced as far as the range of penalty? You understand that?
Yes, sir.
As far as, and that's true of the DUI too. You understand that since you have this DUI and it's your second, if you get another one, it'll be even more serious because of this plea.
Yes, sir.
Okay, will you hold that up, the signature up to to your camera there, Mr. Shuffett?
Here's the information page.
Yeah, is that your signature on there, right down there on the bottom? Is that your signature?
Yes, sir.
Okay. On the plea agreement?
Yes, sir.
And what are the court costs, Bob? $155 will be the court cost, plus the other normal DUI costs and stuff. I'll give you a direct rundown of that. Order pre-sentence investigation report. Your sentencing will be on October the 14th. Okay. Thank you very much.
Now, that was just an indictment you gave me.
Josh Davis. Carmel versus Josh Davis. Carmel versus Josh Davis, 21 CR 00040. Are you Josh Davis?
Yes, sir.
Your Honor,
We're here for a pretrial conference. What are the last four digits of your social security number?
7367.
Okay, counsel, you're represented by counsel here today. What do you have to say, counsel?
Yes, Your Honor. I'm talking to Mr. Stockton, the co-defendant on this case is still outstanding. We were going to ask to set this to the October trial conference day.
That's correct, Your Honor. I was going to get a trial date today with Mr. Manus, his co-defendant, and Mr. Davis, but Mr. Manus is left. Also, there'll be another indictment on Mr. Davis next month, so we'll need to get that taken care of before we set a trial date.
November the 4th?
That'd be fine.
Okay. November the 4th. Okay.
What is this bond currently? So we had a bond that was revoked.
He didn't have a bond. Yeah, it's revoked. Okay. Matthew Denny, Commonwealth versus Matthew Denny.
Your Honor, that case is set for trial the 19th or 20th of October. Mr. Carroll made a proposal to me. There's 4 different cases with different victims, and I've been trying to arrange a meeting with them, and I've been unsuccessful because of my schedule. If you can pass this till the 14th and give me time to meet with them, we may have a resolution or we may not. We can just pass the pretrial. Leave the trial date.
Well, if you could reach, I will tell you that we need those 2 trial days. So if you get the earlier, the better to meet. We might be able to schedule something else.
I'll do my best. It's just a logistical nightmare.
Okay, so you want me to go ahead and put this down out till, well,
yeah, I mean, we can have another pretrial in October if you want to, or if we announce we've got a plea, we can put it on in October.
well, of course.
But I've got at least 5 people I need to
Okay,
meet.
I understand. I'm not saying it's not difficult. I'm just saying if we wait till October, we won't have a trial.
We might set some backups next week in Monroe if we need to.
Yeah, okay. So y'all, I'll set him on the 14th to enter a plea or a pretrial. Okay? Okay, thank you. Sherman Hensley. Commonwealth versus Sherman Hensley, 21 CR 0027. Are you Sherman Hensley?
Yes, sir. I am.
Also have 21 CR 0038. We're here on a pretrial conference on both of those cases. What do y'all have to say?
We've tendered an order for him to be evaluated at KCPC.
Okay, I'll sign the order and probably I'll make next case November the 4th unless by miracle it be done before then, okay? Okay. Yeah, have a great day. I hope, yeah, have a safe trip home. Gary Latimer.
Gary.
G.
Hi, Gary. Come on. Open your eyes, Gary.
Can't see.
Here, turn right here. Right here. Right here. Open your eyes, Gary.
Commonwealth versus Gary Latimer, 21 CR 0091. Here for the purpose of arraignment, who represents Mr. Latimer?
I do, Your Honor.
Okay. Give me his file here.
Open your eyes, Gary. Open your eyes for me.
The grand jury of Clinton County has returned an indictment against Gary Latimer charged with assault with 3rd degree, 2 counts, disorderly conduct, 2 counts, and terrorist threatening, 2 counts. Mr. Latimer, do you understand those charges? Mr. Latimer? You understand the charges? Mr. Latimer, can you hear me?
We can hear you, Your Honor.
Well, can Mr. Latimer?
Your Honor, if I could intervene, I filed a motion for him to go to KCPC. Now, I've got different statements from the jail. I
Okay.
don't know if he's either acting or if he's got legitimate problems.
Okay, well, you acknowledge his identity, Mr. Shuffett?
Yes, Your Honor.
Okay, you acknowledge receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions, and I'll sign the order referring him up for evaluation, okay?
Do we want to set it for November 4th, like the other one?
November 4th. Okay, thank you.
Oh, Gary.
I don't know if he's done it over yet or not.
Well, not right now. We're doing court. If you can bring me one later, I appreciate it. Rocky.
Yeah.
Rocky.
Small versus Rocky Allen Machino.
You're from the judge.
Yes, sir.
Okay, this is 21 CR 0057 and 21 CR 0086. Are you Mr. Machino?
Yes, Your Honor.
Okay, we're here today for sentencing. Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Any reason
Barry Krause and
should not
ask
be
him when he's going to
sentenced?
orient Mr. Machino.
Is it significantly correct, Mr. Shuffett?
Yes, Your Honor.
Okay. Is there any reason why he should not be sentenced?
No, Your Honor.
We'll have to ask Carson. I can't remember who it was.
On plea of guilty to indictment number 21 CR 0057 for the charge of possession of controlled substance, offender shall receive a sentence of 2.5 years. Upon guilty to Cumberland Circuit indictment 21 CR 007, which was transferred to Clinton Circuit Court to be joined with 21 CR 0057 for possession of controlled substance first degree, the defendant shall receive 2.5 years. On plea of guilty to 21 CR 0077 and 21 CR 00 for the charge of operating motor vehicle with alcohol concentration 0.08, first offense, first degree, the defendant shall pay, strike first offense, put, or other substance. Defendant shall pay a fine of $500 across the 2.5 year sentences shall run consecutively a total of 5 years, probate for 5 years. He shall retain time served. He shall go to Clinton County Drug Court. A drug court order was submitted to the court and signed on early in August of 21. All the fine, what's the total fine and court cost? Was there just one DUI here, gentlemen?
I think
Yes,
so.
Your Honor.
I'd have to look. Rocky Machino. Does he? I can't remember his him.
$760, but what was the fine? Plus $500 plus $500. $1,260, and you'll need some time after you get out to pay this, will you, sir?
Yes, Your Honor.
And pay start paying $100 a month, starting 30 days after your release.
Okay.
And the probation and parole officer.
Your Honor, I just wanted to put on the record, there is a third case, 21F41, which is unindicted, which I think the Commonwealth had agreed to dismiss pursuant to the pleas in these two cases.
That's correct. It's another possession case.
Okay, well, y'all send me an order on that, a separate order. And the probation and parole officer will still need information. And so
Yeah, he's supposed to be oriented for drug court at some point in time, I think.
Yeah, so the probation parole officer will contact you there in jail, okay? Okay, thank you very much. William Moore?
Thank you.
William Moore.
William Moore? Commonwealth of Kentucky versus William J. Moore, 20 CR 00013. Are you William Moore?
Yes, Your Honor.
Here for a revocation hearing. Our last four digits, social security number 4577.
Yes.
Okay. What do you have to say, Mr. Stockton?
Your Honor, he has a 3-year sentence on possession of a controlled substance, first degree. He's had 1 failure non-report and 2 positive meth tests recently. And I'd ask that he be placed in the specialty court in lieu of revocation if he wants to do that.
Your
Honor, he's agreeable to that. We'll submit an order for an assessment.
Mr. Moore, you're agreeable to going into drug court?
Sir.
Okay, well, I'll give you a chance. You got a break here. You don't need to make any other mistakes. You understand what I'm saying? So I'll sign the order. They'll come over, evaluate you, and when they get ready to admit you, I'll sign an order to release you, okay?
Thank you.
Caleb Purdue, Commonwealth versus Caleb Purdue. Commonwealth versus Caleb Purdue, 21 CR 0022. Are you Caleb Purdue?
Yes, sir.
You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir, I have. I've looked at it a couple times and I don't see a drug court where it says I'm gonna be going into drug court on here. But I was assessed for drug court already and I'm supposed to have court on the 13th for orientation. So I really don't know I only got 23 days left of my 180. I didn't really know exactly. I'm fine with taking the plea. I just didn't know if, it was all right. I finished just to go straight into drug court. Wait on drug court to come release me or?
What's the Commonwealth have to say?
He can't go into drug court till he's final sentence. That's the rules that I understand. He has to be final sentence. I think
Okay.
Monday drug court meets. I don't know if he's been accepted yet or not. I'm sure he's been assessed. But if
It's not in the plea agreement.
oh, it's not in the plea agreement. I thought he was drug court.
Well,
wasn't.
here's what happened, gentlemen, is it was part of our plea agreement, but I don't think it got reduced to the writing. There was a drug court assessment tendered and signed by the judge, and apparently a drug court assessment has actually been done. And I'm sure Caleb would be on the docket to be voted on by the drug court Monday. So, I would just ask.
If you got the original document there, you just need to pin in.
Well, I think the original document's probably in the court file.
I got the special court agreement of participation.
There's no problem. There's no problem. We're just trying to get it into the plea agreement.
Okay.
If we pin it in, I'll come in and initial it, and Jesse can do the same. And I think that would be
That'll
fine.
be sufficient. It's on the record. Y'all just come in and pin it in on both of them. And it might be a few days after you serve your time before you get released, depending on when they can accept you and do your orientation. Okay?
Okay. All right. Well,
Thank you very much.
Your Honor, will I do my time here or in the Clinton, in the county, or to wait on drug court, or how will that work? Is it all right if I stay here?
How many days you got left?
23, Your Honor.
Well, you'll probably be there for the next 23 days.
Your Honor, I've got no objection once he's ready to be oriented to let him out. If that's all right.
Well, Caleb, it could be that you'll get released next week. Okay.
Okay.
Sometime after Monday.
Okay. Thank you very much.
All right,
Lucas,
thank you.
Lucas Pettinger. Commonwealth versus Lucas Pettinger, 21 CR 00080. Are you Lucas Pettinger?
Yes, sir.
Last four digits. What are the last four digits of your social security number?
0933.
Here today for pretrial conference. What do you have to say about this, Mr. Commonwealth Attorney?
I have a felony plea, Your Honor.
Okay. A motion has been made that says that you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment 21 CR 0080?
Yes.
Is your judgment impaired today in any way?
No.
Have you had plenty of time to discuss this with the matter with your attorney? Are you satisfied with his advice?
Yes.
You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that?
Yes.
Guilty plea, today you give up all those rights. So is this going to be a felony plea?
Yes.
Yes.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I shall await the pre-sentence investigation report on probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 1 year to serve. The Commonwealth opposes probation.
Is that what you agreed to, sir?
Yes, sir.
Okay. Has anyone, including your attorney, threatened or coerced you, offered you anything else to enter a plea?
No, sir.
Pleading guilty because you are guilty and for no other reason?
Yes, sir.
Okay. I will order a pre-sentence investigation report done by probation and parole. And knowing your constitutional rights is still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment within any range permitted by law.
Yes, sir.
Is that your signature on the offer there? Hold that
Yes,
up.
sir.
Okay. I accept the agreement, order pre-sentence investigation, under probation, roll schedule of sentencing for October the 14th. Okay. Thank you very much. Mickey Shelton.
David Krause said that Diamond and Simmons are on their way. Keith and Phillips both live in Lookout Town.
Mickey Shelton.
Simmons. Keith and Terry Phillips. I don't know who Keith is.
Are you Mickey Shelton?
Yes, I am.
I believe Michael Keith.
Mr. Stockton, Mr. Stockton, y'all's microphone is on.
Oh, okay.
On the record. 20 CR 0084. This is Mickey Stockton. What are the last four digits of your social security number, sir?
7583.
Okay, you're here for a status hearing. What does the Commonwealth have to say?
We have a felony plea proposal, Your Honor.
Okay. Mr. Shelton, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Just plea freely and voluntarily given.
It's freely.
And voluntarily given.
Yeah.
Yeah,
I volunteered to give it.
okay. Are you the same person named in indictment number 20 CR 0084?
Yes, I am.
Okay. Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Okay, you understand that you do not have to enter a guilty plea today. You have certain
sir.
rights, and before I can accept a plea, I need to know if you understand those rights. You'll listen carefully. You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge against you. You understand those rights?
Yes, sir.
Is this a felony plea?
Yes,
Yes, Your Honor.
If by entering this plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence by the law. I do not have to accept the recommendation. Prior to accepting your recommendation, I will wait the precinct's investigation report from probation and parole. In the event that I do not accept your recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Listen very carefully to the Commonwealth's recommendation.
Yeah, first of all, Your Honor, he will plead guilty to assault third degree. There is a mistake in the plea papers. It says dismiss assault third degree. That should be marked out, Mr. Shepard, and I'll have to initial that. And upon a plea to assault third, he will receive a sentence of 5 years, serve 418 days. That's calculated through final sentencing on October 14th. And then he would be probated for 5 years supervised. And then he would have no contact with Officer Cross or his family. He would get out and maintain gainful employment, pay court costs at the discretion of the court. Now, this is in agreement with the officer, Your Honor.
Is that what you agreed to?
Yes, it is.
Okay. Knowing your constitution, now you realize that with a felony plea that you've had any felonies in the future, that the sentence could be enhanced under persistent felony offender law because of this plea. Do you understand that?
Yes, sir.
Okay. Is that your signature on the motion and offer?
Yes, it is.
I'll order a pre-sentence investigation report and bring you back for sentencing on October the 14th. Next case is Commonwealth of Kentucky versus Robert Lee Smith.
We just need a trial date, Your Honor.
Are you Robert Lee Smith?
Yes, sir.
It's 21 CR 0072. Mr. Shepard, is this your client?
Yes, Your Honor.
What are the last 4 digits of your social security?
3749.
Stockton, you believe the Monroe trial, Commonwealth versus Cisneros will take place?
Well, if the defense counsel's ready, it will. That's Mr. Poindexter's case. When's that set for? Cisneros.
26th and 27th of October.
Yes.
And you got Commonwealth versus Denny on the 19th and 20th.
Yeah, I really don't want to reset Cisneros because we did about 20 subpoenas with all those officers out of
Well,
state.
I'm not asking you to. I was just asking if it was going to go.
Yeah, I hope it does. It's my intent for it to go. I don't care to go to December on this case or sometime in November if you want to. It'll be a good time for Mr. Smith. He was in possession of about 17, 18 grams of meth, so more than likely at least get a possession conviction.
How about on the 8th and 9th of November?
Judge, if that's the only day we can do that, I can make it work, but I got responsibility in Casey Circuit Court that day.
Well, how about the 11th and 12th?
That's
Yes, sir.
Veterans Day, the 11th. How can we have court?
Okay, 11th's closed.
Can we do this in one day, Jesse, you think?
No, we can't do it on the 12th. We can't do it one day. I'm not going to schedule anything, try to do it without a day after, just in case.
Okay, what about the 15th and 16th?
We got
a big trial in Monroe County.
Yeah.
Okay.
What about the 29th and 30th? Is that district court here
Judge, we could do that. That's,
We have a civil case.
on the 29th and 30th of November?
Yes.
I don't have it on my docket. What-
Your Honor, could we put this on the
Wait a
22nd,
second, wait a
23rd?
s- wait a second. What
Evans versus Pickerel.
is that, Monroe? I thought that had been settled. Who are the attorneys?
Mike John. It's the agreement. Rogers Park has, but they still have.
That guy's off there forever. What's it? That's-
29th and 30th of November.
I have a civil case set that day, but did y'all say you could do it on the 29th and 30th?
I can.
Yes, Judge.
Okay, 29th and 30th. Okay. Okay, anything else? Have a pre-trial on that in October. Is there any negotiation on this case going on, or?
I think my last offer was 10 years to serve.
Okay, okay. 29th and 30th, we'll have a pre-trial on October the 14th. Okay, thank you very much.
Cases.
Is there anybody else down there in jail that we haven't seen?
Mr. Kluger was an add-on.
We have,
No, sir.
we have Emmanuel Fluter. That for release of certified copies of medical records.
Yeah, Your Honor, for some reason, we could not find, and I don't know if I've obtained them and lost them, but the Clinton County Hospital records, the emergency room records, we cannot find those. And I'm wanting to obtain another copy because the emergency room physician may need to look at them when he testifies.
Okay, I'll sign an order if there's no objection.
Your Honor,
If I
there's no objection to the request. This is obviously no waiver to admissibility, but there's no objection to the request.
Yeah.
Now, we're still scheduled for that trial to go. Has there been any other negotiation or are there any other motions? I know there was an issue that was brought up concerning the level of medication. If y'all got any resolution, there's the defendant right there.
Well, Your Honor, I think COVID has kind of thrown a wrench into things, and I think that's probably prevented that test from being taken because Emmanuel has been in quarantine until maybe just today or yesterday. And also that has prevented us from being able to see him face to face and talk to him. And Lauren and I are going to try to do that this afternoon.
When can the test be taken?
Well, I don't know. The jail will have to answer that.
The blood test done, can they come down there? Somebody come down there and take some blood from him in jail?
Yes, Your Honor.
Okay, so you just need to dispatch someone down there and they can do that today. I mean, this date is right up on us.
I know me and Mr. Hunley was working on the case yesterday.
Yeah, well, I know, but we got all this unresolved stuff going on. It bothers me that we haven't taken these blood tests. It's not the Commonwealth's fault, maybe not the defense fault.
The jail's been on complete lockdown.
Yeah,
Nobody's been letting
yeah.
anyone out. That's-
And he got locked down too, but, you know, I'm not saying it's anybody's fault. I just don't know whether you can ever get the results of the blood test back and any expert to look at it by the time the trial's set.
And I take it too, the deadline's expired as far as any mental health expert from the defense. You're not going to have, I've not received a report or anything. I guess you're just going to rely on the KCPC doctors.
We will have, and he won't necessarily be testifying in an expert capacity. He'll be more like a fact witness, but we will have an expert who observed him early on, and then later, and then a few months later, around the same time we went to KCPC. We do anticipate he'll be called as a witness, although it won't be in an expert capacity.
He won't be rendering an opinion.
Not regarding criminal responsibility, because he was not
Well,
asked to do so.
Any mental defect, the rule requires me to have discovery within 20
Well,
days. of
we are
trial.
asking him to prepare a report for you to review.
Well, the time's expired, so if I don't get it pretty soon, I may be asking for a continuance.
Well, y'all need to talk to each other today. I'm right on the verge of doing a continuance anyway, because of this stuff, you know. I just think that if there is a question as for this serious charges, both of you know that, both of you handle it seriously. But
This is
if
as
there-
serious a case as I've handled as Commonwealth attorney.
But if we've got some issue about this medication, and here we are 2 weeks beforehand, and you come up with this blood test and you have an expert witness that hadn't been relieved and says that it would affect his capacity or that sort of thing, then how will the Commonwealth be able to work somebody in to take a look at that and testify contrary to that? I just don't see how it can be done. So y'all talk to each other and get back with me. By the beginning of this coming week, we can talk about whether we're going to be able to proceed or not. Okay?
Okay, thanks.
Thank y'all very much.
I'll start. I'm gonna go in the hallway. What do we do then?
But any of these, Mr. Cross's clients can be brought in. How many of them are there?
Is he the only one? No, there's a John Diamond.
Just call them. They just call these people and see if they're here. Call them out in the hallway. Get behind the podium there. What's your name? Let him have my file. Get his file in. I'm on Kentucky versus Jimmy K. Simmons, 20 CR 0085. Mr. Simmons, your attorney was not able to be here today. The Commonwealth, do you need a negotiation day in this case, Mr. Commonwealth Attorney?
No, Your Honor, Mr. Cross has furnished me some discovery. Can we just set this for November? Because I've got a bunch of out-of-state victims I need to contact after I look. at
November the
discovery.
4th, you're under the same bond. You'll be back here with your attorney on November the 4th, okay? Thank you very much. Who else we got? Yeah, recall the warrant on the gentleman that just left. Mr. Diamond in his file. Commonwealth Attorney versus John. Hell, they get in here without me. Commonwealth Attorney versus John Diamond. Commonwealth of Kentucky rather versus John Diamond. Mr. Diamond, your attorney was not able to be here today, but Mr. Commonwealth Attorney, when do you want him here next time?
Well, he's got a September the 20th.
You what?
Yeah, he said for September the 20th, so he don't need to be back to trial.
Who's on the docket?
Yeah, I guess this was gonna be a plea day. Then, Mr. Cross has been absorbed in another case, I guess.
We set him a trial date, free trial last night.
Yeah. Okay. So this is the pre-trial. The trial date is what?
September 20th.
You'll be here September 20th for your trial.
Yes, Your Honor.
Okay, thank you.
Okay, thank you.
Withdraw the warrant on it.
What about the other people who didn't?
This one did. So we got Terry Phillips, Sherry Sue Barnes, Connie Brown, and Shannon Mercer. So I'll just wait. Somebody needs to call Mr. Cross's office and tell them that those 4 people need to come up. Can you get somebody to do that, Sheriff? And then I will withdraw the warrants on each one.
Today, sir?
Yes.
Okay.
Yeah, and I will withdraw the warrants on them when they come up here, okay? Won't be served till they get an opportunity to come.
Was there another motion on Jennifer Stockton set on the docket by Mr. Sheffield? I received one at the office.
I received one yesterday afternoon, very late yesterday afternoon, not in time to put it on.
Mr. Shevit, do you have anything else? Who was that you just mentioned?
Jennifer Stockton, it didn't make it on the docket because the motion was filed late yesterday afternoon.
Yeah, that was a motion for continuance on her trial. On second.
Okay, say it again so Mr. Stockton can hear you.
That was a motion for continuance at the trial, that trial on October 22nd. I talked to Mr. Stockton about this earlier this week a little bit. I would review the case and talk to Jennifer about it. Unfortunately, we were not able to reach a plea agreement, even though Mr. Stockton did make a legitimate 25-year offer on the case. And there's an issue in the case regarding a client of mine ended up charged with trafficking based upon a stop. He says, well, I mean, technically, both myself and my supervisor agree that this stop can't receive the representation.
When is it scheduled?
So I have submitted a conflict request within my office. But I want to go ahead and make a motion for, because I'm sure we could.
Is your client incarcerated?
She is.
Okay. So we have Commonwealth versus Keith, Commonwealth versus Cash, and then we go into Smith Barnes.
If you continue this stuff, as long as you waive her right to speak in trial, I don't care.
Okay. Can you get a waiver of that signed? Have her sign the waiver. Okay, thank you. Does that finish the criminal docket? What I'm going to do is I'm going to proceed to the child support and the civil docket. And if any of these people who have not come in because extenuating circumstance for the attorney come in, bring them in, and I will reset their dates. Mr. Stockton, you'll need to have someone available. Let me have these 4 cases that are left.
We wanted him to go.
Yeah, the 4 cases that are left, if there's anything other than resetting those for the next motion day, you need to tell us, okay? knock on the door and get Mr. Stockton back out here. Okay, Mr. Stockton, while you and the sheriff are here, we got 4 people left. Is that correct?
I think that's right.
4 people left that were Mr. Cross's clients. I'm going to allow them, if they appear today, to have the warrants withdrawn. You need to look at those 4 cases and see if there's anything you want done other than let them be set at the next rule date. Do what? Okay, okay, well, just,
Mine was just contacted Mr. Cross's office, told him I need to be here within the hour.
okay.
But the arrest was issued.
Okay. So, and so the other 2 should be set, if you want a pretrial, is what I'm trying to say. If you want a negotiation meeting, and you and Mr. Cross can work it out if there's anything else, okay? Okay. We'll do that, and that way you won't have to hang around. Okay, I guess we're coming over to the child support docket now. Child support docket. Pillar versus Pillar, 08 CI 0044.
In this case, we're gonna pass this.
Garnishment's been issued.
Yes.
Davidson versus Davidson.
I'm sure. We're gonna have that.
Tahani versus Frankie Davidson.
Tahani versus Frank 06 CI 00120. Motion or survey.
She's out, so she's just.
Cooksey versus Cooksey. 07 CI 003.
In this case, we pay 208 a month of current, 50 on arrears. The balance right now is 730.19, the rest of the 550 we pay off.
Okay. Van Winkle versus Van Winkle.
In this case, 7 months of current, 25 on arrears, and the rest of 750
This person been in contact with your office?
Oh, Your Honor.
Where did you serve him at? Okay. Cabinet versus Gillen.
This case, this is paying 325, 75 a month on arrears, the rest of 650 over 13.
Cabinet versus Bale.
In this case, 99 a month on current, 60 on arrears, the rest of 750 we pay October 22.
There's people in the hallway not wearing a mask. John Diamond's got his off again.
He didn't know how to put one on. Cabinet versus Cooper.
Your Honor, we have an order to dismiss. It's not possible.
Bennett versus Harvey.
Under this case, order to take 42 bond of first.
That concludes your docket?
That does, Your Honor.
Okay. Okay, we have the EPO, DBO docket. Moons versus Moons. Did you look at next Wednesday? Where is your client today?
My client was notified by the clerk's office that Mr. Cross is going to be unavailable today. We called the clerk's office, they told us to call Mr. Cross's office. His office indicated that he was not here today and that the motion was going to.
It's unbelievable. It's unbelievable.
Next Wednesday, we'll hear on this declaration motion.
I'll set this up for October the 14th.
15th. September 15th.
No, I'm setting it for October the 14th.
It can.
I just did because she's gonna wait. Your client has no problem with that.
No, she doesn't.
Okay. And they can object to it if they want. In the future, if the clerk's office calls you and tells you anything like that, you can rely upon it. But you need to call our office about your attendance or not. Mr. Cross wasn't here today. He did call us, contacted me, but he said he wanted to keep these two things on the docket. It's the last information. He had two matters, and I told him that we were not going to consider his motion. For he had a motion about custody in this case. And I assume you're involved in the divorce case too. I told him I was not going to hear that case until the EPO was resolved. And next week was mentioned, but if he wants to be here next week, you and he can work it out. Other than that, it's going to come back to next time because he was scheduled to be here and he had a conflict. He got a trial. But I'm going to be here on what do we have on the 15th?
Suppression hearings,
How many of them?
multiple.
See, I've got multiple suppression hearings on the 15th. So, I mean, would you like a hearing on the 15th?
I am available that day.
Okay, well, you contact Mr. Cross and see if you can buy agreement. I'll work y'all in on the 15th. But if not, it's scheduled for the next rule day. Okay, thank you very much. We got a 5-minute break here. Everybody enjoy. Let's go off the record. Are we off the record?
I believe they're gonna be getting a schedule a hearing with the DRC.
Okay. To the DRC Bulls versus Gibson.
Mr. Cross.
The parties in line in this case, David Frost represented the father, contacted, my for today, and he stated that his opinion of this is it just needed to be ruled on, and so he did not feel that his presence was necessary.
He's in trial today. He's in trial today. So you have to catch me up on this thing.
This is a post-decree action with two pending motions to modify time sharing based upon this control being arrested for trafficking methamphetamine. We've got two cases pending related to that. Guardian of the Blind was appointed, and she has filed a motion to allow Mr. Grohl's parents to intervene as, I don't think intervene, to allow them to have grandparent visitation rights because the claim is that his time sharing has been limited because of his parental activity. You asked this previously on the before you asked the question to brief it. You did brief it, and it's been submitted to you. If you have questions about it.
Okay, we'll make sure we get copies of the briefs here. Did you send those directly to us, or did you?
I think I sent them to you and to the court.
I don't have Mr. Cross's, is the one I don't, but I'll get a copy of it.
We'll get copies of it. Since is there a way you can reach an agreement on this? You don't think? And what's your position on it? Well, the problem is quite frequently, people see that as a subterfuge to allow visitation with a parent that's had limited visitation because of their actions. What do you have to say about that? Did you address that in your brief?
So I don't believe I addressed that specifically.
That's your problem, isn't it?
No, we have several problems.
You have other problems.
Not the least of which is stand compliance with the statutory law, compliance with.
And I recognize, Your Honor, and I did in my motion and in my brief both state that I did believe that any contact that the child has with the father should be closely monitored. I'm not sure to what extent the grandparents are prepared to exclude him from that time entirely, but I would, personally, I believe it would be appropriate in this instance to have an evidentiary hearing to take testimony from the grandparents on to what extent.
You had any plea or anything? He's just been charged.
I think he had told me a week or two ago. I don't know what the original that is
He-
being. Mr. Cross representing.
There's an indictment on him. Mr. Cross did not file a memorandum, that's why I didn't receive it. That's what we. It is not in the file.
Did you get us a copy? Okay, we'll take it under advisement. If we think we need those things. The problem that I have with these things, you get all these people charged, you want to make sure everything's all right, but if they were convicted, they would have certain rights to visitation in jail, and if the circumstances are correct and the location is safe, it might very well be that the grandparents don't have standing. It could very well be that they don't have standing. I don't know. But if they didn't have standing, I could order visitation with the father with them being the supervisors. You know, I mean,
Yeah, that's what it is.
At this point, they have Wednesday visits and then they have visitation every other weekend as well. My position was added. Visitation. So before this, they were on a 2-2-3 schedule. That's what the child was on.
We responded to all that.
so you don't have any problems with the level of visitation that exists. You don't have any problems with the level of visitation that exists now. You just don't want
The
more.
same thing the court has ordered since 2018 is what he.
Okay, well, that freshens us up about a little bit. We'll take a look at this and give you an order on it, okay? Dennison versus Woodbridge.
Yes, sir.
It's a motion to dismiss.
Yes, Your Honor, the parties without the intervention of council got together and worked it out. I filed a motion. David Cross's office called my office yesterday saying he had no objection.
Okay. It's awful when your clients work things out. It's terrible.
Yeah, cuts down on legal fees.
Yeah, it does. Okay, thank you for being here.
Thank you, Judge.
Johnson versus Huff.
That one, I believe that's been renoticed.
You notice? Stearns versus Stearns.
Good afternoon. There may be a pre-file time of attorneys. You have to file first. Thank you.
Did you grant that motion to dismiss?
Yes. I think I already signed it yesterday. I think it was an order. Or maybe I just read it last night. So I just thought how usual it was. The parties get filled up with all these things. Children involved in this, and I'll let staff while you look at it and enter it. If there's any problems, we'll call you. Kelsey versus Kelsey.
Continue to the next motion day. By that time, there will either be a default yes or agreement. So we'll be ready to show you submitted at that time, but they're not having any problems right now. Exactly.
I don't know how you lawyers are gonna make a living if people settle without you like this one and they're getting along. That's terrible news.
Yeah, but they are.
Okay, thank you. Sitting jest of it. Catherine versus Anderson.
DRC.
For the DRC. Moons versus Moons. That case was continued to be renoticed. They'll renotice it hopefully for the 14th of October. Is there anything else?
We have domestic cases, but we don't have any dockets.
Sure.
Myers versus Myers. Ms. Capps and I motion submitted for about the parties have.
You have that file? Wait a second.
Is it on the docket today?
It didn't make it to the back.
The part is only issue.
Let's find the file first. No children involved.
There is, and we agreed to custody, everything's worked out, except there was a restriction. An 8-year-old niece of the father, alleged contact with one of the children. We've had a hearing for waiting on. Well, we haven't submitted our briefs yet.
only thing I bring up to her, just that fit is. Fit's gonna go.
Not fine, I'm not sure, but he stated that he knows the date, and he may just not have it, on schedule yet. But I put a clause in there that no party shall exercise time sharing until they completed it. I'm not sure if any of the clients have either.
That's what I wonder, if neither one of them has, then how can either?
But I've made her aware that if they haven't, then they need to schedule it, so I'm sure. it's
Or they need to do it. Once you tell them that they need to do it, and get proof in it, we'll enter the decree, okay?
Okay, I'll do that. I'll have a phone call. Let Angela know.
Okay, thank you very much.
I thought it's a mailbox stuff.
Maybe.
What about the rest of you people out
Good afternoon, Judge.
there? There is someone out there.
George Bertram.
They turned the camera. What do you got?
I got a Zoom notice for Angela Raines this morning, sent an email that I no longer represent her, that said I would log in at 1 o'clock after I got through my family court stuff to see if the court needed me or for any reason. I think she filed a pro se motion.
You want to, if you want to send us an order to validate your withdrawal, we'll be glad to sign it, okay?
Okay, thank you very much. Have a good day.
Thank you.
It wasn't in here, Justin.
It's on the docket, and they got taken off.
Wade Mountain Road, Flavor versus Flavor. Okay, and also we need domestic or confidential dockets. We didn't get any of them. We have 2 cases on. Yeah. Well, maybe it's- Yeah, 2.
Well, if they're ready. Now, we broadcast now.